DNA samples found on those items. This collection can occur without probable cause or even after an individual invokes their right to counsel. The NYPD contends that this is a legal practice underneath the Fourth Amendment, relying on judicial rulings related to abandoned property, such discarded garbage which police can search without a warrant. However, critics argue that discarding an item while in police custody is fundamentally different from discarding trash in a dumpster or garbage can on a public street. Although the NYPD has taken commendable steps to improve transparency and consent regarding its collection of DNA samples from suspects and arrestees, the department continues to collect DNA samples from minors through deceptive means and without consent. Although I agree that law enforcement must have the tools to solve crimes, doing so should not be done at the expense of fundamental rights of individuals. New Yorkers deserve clear protections, transparency, and strict limitations on how DNA is collected and used, which is what Intro 125 seeks to provide. The committee will also hear Introductions 798, sponsored by Council Member Stevens, legislation that will abolish the NYPD's criminal group database and prohibit the creation of any successor database with similar functions. The NYPD's criminal group database, commonly known as the gang database, is used by law enforcement to track alleged gang affiliations and criminal networks. The department maintains that the gang database is a vital law enforcement tool that assists criminal investigations and enhances public safety. However, advocacy groups have long criticized that the database, due to concerns about vague criteria for adding individuals, a lack of notification to those listed, and the absence of an appeals process. These issues disproportionately affect Black and Latino communities, as over 99% of individuals in the database belong to these groups, which in turn can subject these populations to undue surveillance and harmful law enforcement interactions. '23 Department Investigation Report confirmed inconsistent data entry practices and inadequate oversight of the gang database, recommending significant reforms, particularly for minors. Although the NYPD has revised some of its policies, key concerns remain. Effective policing must balance crime prevention with fairness, ensuring no system unfairly targets or stigmatizes entire communities. As we will discuss these bills today, we must ask ourselves, how do we strike the right balance between public safety and protection of civil liberties? What safeguards must be in place to ensure that policing in New York City is both effective and just? Our goal must always be to build a system that upholds fairness, accountability, and trust between law enforcement and the people they serve. I look forward to hearing testimony from key stakeholders today, including representatives from the NYPD, legal experts, advocates, and community members. Thank you for being here and for your engagement in this important conversation. With that, I'd like to turn it over to our public advocate to make a statement.
Thank you, Mr. Chair. Much appreciated. I also want to note that it is before noon and I'm present. Good morning. My name is Jamani Williams and I'm public advocate for the City of New York. I want to thank Chair Salam and the members of the Committee on Public Safety for holding this important hearing. Since 2013, the NYPD has maintained a database of what they characterize as intelligence regarding criminal groups and street gangs. This criminal group database, or CGD, or as it is colloquially called, the gang database, according to the NYPD, contains about 16,000 entries and allows them to discern trends, relationships, and patterns to enhance public safety and criminal investigations. However, advocates, lawyers, and individuals in the database themselves report that it is largely full of men and boys of more color, many of whom have no gang affiliation at all. It is unclear how or why an individual gets added to the CGD, and it is even less clear how someone can get themselves removed from it. Wishing a gang member a happy birthday on social media, being outside late and wearing a certain color, and living in the same public housing complex as an accused gang member are all potential reasons for a person to be added to the database. In the last few years, the NYPD has expanded self-admission criteria to including social media postings, which can include emojis or hashtags, or other unclear and undisclosed criteria. This raises questions not only about the interpretation of these posts as admittance of gang membership, but also of whether the NYPD can definitively attribute a post to an individual. I think anyone who uses social media can relate to posting something without thinking or something that was misconstrued. It does not mean that they are admitting to being in a gang. A report from the Office of Inspector General for the NYPD found that 99% of those in CGD are Black or Hispanic, 98% male, and contain kids as young as 13 years old. These demographics are reminiscent of the abuses of stop, question, and frisk. In 2023, 59% of Terry stops were of Black people, and 30% were Hispanic, in a city that is 36% white. This looks like disproportionate targeting of certain communities. Being labeled as a gang member by the police wrongfully or otherwise often results in increased police harassment, stops, and arrests. This interrupts schooling and employment and can even result in incarceration. It is also not the best use of police resources that could otherwise be used to respond or help solve crimes. Individuals labeled as gang members face obstacles in court as prosecutors can raise alleged dangerousness when judges set bail, and claiming gang affiliations can easily color a jury's perception of the defendant. It is a damaging allegation that is almost impossible for someone to refute. Contact with the criminal legal system can cost a NYCHA resident their housing, which is especially troubling given gang takeovers appear to target public housing and the surrounding communities. And while we don't know if gang takedowns in New York City have led to deportations, the gang label presents serious and unique legal problems for non-citizens. With President Trump in the office and Mayor Adams collaborating with immigration enforcement at the behest of the administration, it is especially urgent to ensure that we are not mislabeling people as gang members. Today we are hearing some bills, including Intro 738, sponsored by Councilmember Stevens, and of which I am a co-sponsor, which would abolish the criminal group database and would prohibit a similar database from being established. It would also require notification to those in the database, as well as instruction for how they could request records contained in the database before they're destroyed. It is important to abolish the CGD for a number of reasons, including the fact that the NYPD has violated its database entry and renewal process, including renewing inclusion of minors in the database without qualifying police contact, and it does not provide sufficient guidance for gang database entry and lacks enforcement in its review process. The NYPD has also historically been resistant to this type of changes. We should instead try to focus our resources on strengthening communities and supporting young people who are at risk of violence, many of whom have been victims of violence themselves. At a hearing of this committee this past December, former Chief of Department Manager acknowledged that the NYPD has increased presence in under-resourced communities and that he wishes the city would bring more resources to those communities. I agree. We should be using the time and money spent on criminalizing youth and young adults of more color, on investing in education, different violence models, employment programs, affordable housing, and health services. We know what does work to prevent crime and violence. We also know that simply trying to arrest the children of the people we arrested 20 years ago will not get there. I just want to also be clear, the issue for me is not necessarily police involvement, it is the consistent and over-policing. Some of the takedowns that happen, we have to come back several years later to do the same takedown because we haven't done any changes in those communities. Oftentimes I see in the news these type of bills are the problems, and they present the violence from gangs themselves, even though these bills aren't in effect. And so what it looks like is some of the things that we're doing aren't working generationally, and it doesn't seem like a database like this stops the violence that we want to stop, but can cause additional harm to people who now are part of the legal system that now further may fall into more problems with the legal system because they were there in the first place. And so that is the issue that we're trying to fix. I don't want the media to think that people up here are trying to promote violence, want violence in their communities. Quite the opposite, we want it to stop. We also, in my opinion, want to stop asking the police to do everything and try to solve everything. It's unfair to them and it's unfair to the communities that they're asked to solve these problems in. Thank you so much, Mr. Chair.
Thank you. I'd like to now acknowledge that we've been joined by Council Members Ariola and Councilmember Marte and Councilmember Caban. I'd now like to turn it over to Councilmember Stevens for her opening remarks.
Good morning. Thank you, Chair Salam and Speaker Adams, for allowing for us to hold this hearing today and consider Bill Intro 798, which calls for the abolishment of the NYPD's gang database and prohibits the creation of a successor database. I have been on the Public Safety Committee since I've started in council. One of the things that I've said time and time again is that the NYPD needs to rebuild the trust in Black and brown communities, and because of the continuously over-policing in those communities. And the first place I believe that they can start is by abolishing this database. With the database is having clear racial disparities because 96% of the database is made up of Black and brown people. And we all know those are not the only people in gangs. And I would also like to note, being in a gang is not a crime. I wanted that to be clear. I would also like to highlight, like I said, it's not a crime, and it's having them under surveillance. For several years prior to council, I traveled across the city as a member of the Gang Coalition, where I educated communities and young people of the existence of the database, and young people would use the Freedom of Information Law, FOIL, to see if they were on the database because they were not notified that they were being put under surveillance. And for most of those requests still have not been responded to. There is no true data or proof that this database is solely improving any public safety in the community. The lack of transparency has only proven that this database is focused on surveillance and racial profiling. This is not just a New York problem. Similar databases across the country, they have had similar databases across the country, and we've had firsthand seen what happens when cities take the right step to eliminate them. Recent research proved that the elimination of the gang database in Portland and Chicago did not lead to an increase in crime. In fact, it was a clear refute claims that the database the prevention of crime or enhanced safety. Instead, we've seen in cities that remove the database is an opportunity to reimagine public safety, one that is built on investments in communities and not the over-policing of our youth. As a longtime nonprofit worker, youth developer, and now the chair of Children and Youth Services, I have the answer to what we actually need to drive down crimes in our communities. They are investments in affordable housing, education, expanding workforce opportunities, mental health resources for our young peoples and community. This is how we're going to create safer communities. Today's legislation is a small step in which NYPD can take in righting some of the wrongs for many years around creating a true community policing plan rather than oppressing other communities. And I truly believe that we can work together to restore the trust in these communities that have been over-policed and work together to get to a place where we are not seeing such racial disparities. So thank you.
Thank you, Councilmember Stevens. I'll now introduce our panel of administration witnesses and turn it over to the committee counsel to swear them in. The panel will be Deputy Commissioner Michael Gerber, Assistant Commissioner Alden Foster, Chief Michael LiPietri, Assistant Chief Jason Savino.
If you could all please raise your right hands. Do you affirm to tell the truth, the whole truth, and nothing but the truth before this committee and respond honestly to council member questions? Noting for the record that all witnesses answered affirmatively, you may begin your testimony.
Good morning, Chair Salam and members of the council. My name is Michael Gerber, and I am the Deputy Commissioner of Legal Matters for the NYPD. I am joined by Chief of Crime Control Strategies, Michael LiPietri, Assistant Chief Jason Savino of the Detective Bureau, and Assistant Commissioner Alden Foster of the Community Affairs Bureau. On behalf of Police Commissioner Jessica Tisch, we thank you for the opportunity to speak with you today about youth and gangs and about the two bills under consideration. Reducing gun violence is at the heart of the NYPD's public safety mission, and a substantial portion of gun violence in New York City is attributable to gang or crew activity. Those shootings are lives shattered and lives lost, families and communities in pain and grief. The NYPD has a responsibility, a legal mandate, and a moral obligation to use the tools at its disposal to solve those shootings and prevent more shootings. One of those tools is the Criminal Group Database, the department's central repository for intelligence regarding street-level gangs and crews. In 2019, there were over 18,000 individuals in the database. That number is now around 13,200, a 27% drop. In 2019, there were approximately 440 juveniles in the database. There are now approximately 160 juveniles, a 64% drop. There are just over 500 gangs and crews represented in the database. It is true that 99% of the individuals in the database are people of color. It is also true that in New York City, from 2019 to 2024, 96% of the individuals arrested for shootings and 96% of shooting victims were people of color. Our detectives work tirelessly to investigate these shootings and seek justice for the victims and their families. More broadly, the department devotes tremendous resources to prevent additional shootings and save lives. As part of this effort, the database provides crucial intelligence to NYPD investigators. It contains criminal group names, membership, associated incidents, geographic data, and intergroup rivalries and relationships. By consolidating this information, investigators and executives can identify trends and patterns involving gang activity. This information helps the department interrupt cycles of violence and prevent acts of violent retaliation. In particular, when an individual is shot or killed, the database allows us to immediately identify whether that person is part of a gang. That raises the possibility that the shooting is gang motivated. This intelligence assists the investigators working to solve the crime, and even more important, helps us prevent retaliatory violence. One of the many tragedies of gang-related shootings is that one shooting leads to a retaliatory shooting, which in turn leads to another shooting, a cycle of violence that feeds on itself. The key to preventing that cycle of violence is having accurate, immediate intelligence regarding gang membership, location, and rivalries, realizing when gang violence is about to spiral, and intervening quickly to prevent it. If we know from the database that a shooting victim is a gang member, the identities of rival gang members, and where those gangs are based, we can immediately deploy officers in a way that will help prevent retaliatory shootings. Do we always succeed in that effort? No. But sometimes, thanks to the database and the hard work of our officers, we do. Those successes are lives saved, often the lives of young people who would otherwise have become shooting victims. While the information contained in the database is a critical intelligence tool, a variety of protections ensure that the information in the database is not misused. An individual's inclusion in the database is not a matter of public record. It does not appear in a person's criminal history. The fact that someone in the database is not shared with employers, schools, landlords, or civil immigration authorities. The fact that an individual is included in the database is not a ground for a stop or arrest and is not evidence in court. It is not a basis for charging decisions, bail determinations, or sentencing. In 2023, following a multi-year investigation, DOI issued a comprehensive report regarding the database. The report found no evidence that inclusion in the database caused harm to any individual or group of individuals, and did not identify a relationship between inclusion in the database and any individual adverse outcomes. At the same time, DOI made various suggestions for how the department could improve its procedures relating to the database. We have taken the majority of DOI's recommendations, and in several instances, we have made changes that go well beyond those recommendations. It is now much harder for someone to be added to the database. It used to be that someone could be added to the database based on a combination of factors such as presence at known gang location or association with gang members. That has been eliminated. If a detective proposes adding someone to the database on those grounds, the proposal will be rejected. Instead, an individual can only be added to the database if that person has admitted to gang membership, either in speaking with law enforcement or through the person's own social media posts, or if, over the course of an investigation, detectives believe that an individual is a member of a criminal group and two independent and reliable sources have identified that person as a member of the group. Moreover, these grounds for inclusion in the database must be documented. If there is insufficient documentation, the individual will not be included in the database. This strict requirement enables effective supervisory oversight, both through multiple layers of supervisory review and DOI's ability to audit entries in the database for compliance with our policies. We have also dramatically revised the rules for removing people from the database. There is an automatic review process. For adults, it is every 3 years, and for juveniles, it is every 2 years. A person can only remain in the database if that person has been arrested for a violent crime, weapons possession, or a crime in furtherance of the criminal group, is on parole or probation, or is in jail or prison. If none of these criteria are satisfied, the person must be removed from the database. In short, since 2023, we have made it much more difficult to add someone to the database and much harder to keep someone in the database. And the data reflect this shift. Over the last 2 years, 682 people were added to the database, while 3,192 people were removed. The ratio of removals to additions is 4.5 to 1. None of this is to say that our practices and policies involving the database are perfect. We always seek to improve and are open to changes. Intro 798 would not change the database, it would eliminate it. The Inspector General for the Police Department would be required to notify persons named in the database and provide additional information regarding how persons may submit requests for records contained in the database. A member of the NYPD who used the database would be subject to financial penalties and to civil litigation, including for punitive damages. We urge the Council, in the strongest possible terms, not to pass Intro 798 as drafted, and more broadly, not to eliminate the database. It would be a terrible mistake to take this important public safety tool away from the NYPD and tie the department's hands when it comes to investigating and preventing gang-driven shootings and violence. If the database is abolished, gang violence will not cease. Officers will still need to figure out who is in a gang, but without the database, this will happen informally, in a decentralized fashion, by word of mouth. There will be no checks, no documentation requirements, and no possibility for oversight or controls because we will be barred from tracking this information. The result will be confusion, mistakes, and a much higher likelihood that individuals are incorrectly identified by officers as gang members. In response to a gang-related shooting, deployments will be less precise, investigations will be slower, and the risk of unchecked retaliatory violence will be higher. Of course, we wish that there were no gangs and no gang-related violence. Many of the drivers of gang activity and membership are beyond the department's control. But our Community Affairs Bureau has programs designed to meet young people where they are and give them experiences and opportunities that will keep them from street violence. For example, the Options Program helps young people build decision-making skills through career development opportunities, workshops, and internships. The NYPD's Community Center in East New York serves as a haven for local youth, offering educational workshops, social activities, and recreational programs. The Neighborhood Coordination School Initiative provides tutoring, mentoring, and after-school activities for at-risk youth. Our Summer Youth Employment Program employs young people in various city agencies, while the Higher Education Learning Initiative offers high school students the opportunity to explore higher education resources. These programs are integral to our public safety mission because we know that we cannot stop cycles of violence through arrests alone. I also want to speak briefly about Intro 125, which prohibits the collection of DNA from a minor prior to an arrest without the consent of a parent, legal guardian, or attorney. We appreciate the concerns motivating the bill, and to a large extent, we have no objection to the bill. We would only ask that there be a narrow exception applicable when the juvenile is suspected of committing a Class A or Class B violent felony, and the investigators have received permission from the Chief of Detectives. This will be a rare event. But in a situation in which a juvenile is, for example, a suspect in a murder or rape, the Chief of Detectives should be allowed to authorize an otherwise lawful collection of DNA from a juvenile pre-arrest. We look forward to discussing this legislation further with the Council and working towards a bill that gives additional protection to juveniles while still allowing for exceptional circumstances in which this investigative step is permissible. Thank you for the opportunity to testify regarding these important matters. We are happy to answer any questions that you may have.
Thank you for your testimony. I'd like to acknowledge that we've been also joined by Councilmember Palladino. I'd like to start by asking some questions about the city's local DNA database and the NYPD's practices of collecting and storing samples from individuals without obtaining a judicial warrant. How many persons currently have DNA samples in the city's local DNA database? And how many of these samples have been collected from suspects or arrestees? And what is the racial breakdown of the individuals with samples stored in DNA databases? And how many persons have had DNA collected and stored when they were under the age of 18?
All right, so there are a bunch of different questions there. Let me try to cover as many as I can. So there are two different things here, right? One is the database itself, which is not an NYPD database. I think that's very important. It's OCME's database. They control the database. They are the keepers of the data regarding their own database. There is some information that OCME makes publicly available. There's a dashboard they have on their website, basically provides essentially monthly data. And looking at that, there are, this is as of a day or two ago, 33,221 entries in the OCME database. And again, this is this sort of suspect database. So 33,221 searchable in that database. Now, in terms of the breakdown of that database, whether it's demographics or otherwise, we actually don't have that data. It's OCME's data. And to the extent there are questions about that, I think they need to be directed to OCME. Now, in terms of the NYPD and what we sort of send, so to back up, right? If we're taking DNA from an individual, it could be through multiple different channels. It could be via a court order, it could be via consent, it could be via an abandonment sample. And if we do that, it will then go to the lab, will then go to OCME. Now, I should say, just on the OCME side of things, they are not going to even sort of process that sample unless it falls within certain categories. Certain felonies, generally they will not do that for misdemeanors. There are some narrow exceptions, for example, for like sex crime misdemeanors, but generally they will not. They also generally will not process it unless we have something to compare it to. So to the extent you have a DNA sample and there's no objective evidence as a comparator, OCME is going to wait 6 months, and if there's still no comparator, they're going to send it back. Right? So they're actually on the OCME side, and these are their policies, again, which are public. They've imposed all sorts of sort of constraints on what they'll even process, which that in and of itself has a significant narrowing effect. Now, in terms of our collection, and Chair, if I may, just in terms of your question, you want to focus on generally, or you want to focus on juveniles?
The question, that particular part of the question was about folks under the age of 18.
Yeah. So in terms of juveniles, so for example, in 2024, abandonment samples that we took from juveniles, 174. And then consent samples from juveniles in 2024, that number was 7. Now, one thing I do want to emphasize, I think this is important, we don't have good data pre-arrest versus post-arrest, particularly if the arrest happens the same day as the collection. And what I mean by that is, you can imagine a scenario in which whether via abandonment or consent, a sample is taken, later that day an arrest is made, and then that sample that was taken will be associated with the arrest, even though it was taken pre-arrest. So our data doesn't distinguish between samples taken pre-arrest versus samples taken post-arrest, if that makes sense. Obviously, if the bill passes, we will have to track that going forward. The bill distinguishes quite sharply between pre-arrest and post-arrest situations. And of course, if that becomes the law, we will necessarily track these matters.
Just for clarity purposes, and I want to ask this question, given my ignorance in terms of the actual practice of what the NYPD does or what this database, how this stuff is collected. I thought I heard you say that everything essentially is tagged or is collected. This cup thrown in the trash, cigarette thrown in, no matter what or who.
No, that is. If I did not mean to say that. I don't think I said that. That is not our practice at all.
Okay. So
if I may, so certainly when you're talking about juveniles, our policy is very strict on this. There's a limited set of situations in which we would even consider taking an abandonment sample from a juvenile, and this is in our policy. So if we're talking about a juvenile who's 12 years of age, it would have to be an A or B felony. 13 years of age or older, it has to be a felony. We also would allow it for sex crimes, hate crimes, and any crime involving a firearm. It's for juveniles. So, and then for conspiracies to commit these sorts of offenses. So, just to be clear, in terms of even being able to consider doing this in a juvenile situation, again, it will vary slightly by age, but you're talking about either, a felony or a violent felony. And then for misdemeanors, we're talking about sex crimes or hate crimes, essentially. So it's already sort of a narrow field. So most misdemeanors are totally out, and then depending on the age, certain felonies are going to be out. And then, in terms of the decision whether or not to, and by the way, this is true for consent and for abandonment samples. It's for both. Now, once we're in the realm of where a policy would authorize it, then the question becomes, do we actually go ahead and either seek consent or seek an abandonment sample? And that's going to be a case-by-case determination. Obviously, there are many, many situations, frankly, most situations, involving juveniles in which our policy could allow it, but we don't do that. So it's actually, there's both the sort of policy piece of this, and then there's a discretionary piece.
Can I say something, please? Sure. Want to make this crystal clear that if you look at the last 3 years of abandonment samples of juveniles, 99% of the abandonment samples or consent are attached to a felony arrest. 99%.
Yeah, just to put a face on that, it's so rare that we collect these abandonment samples from juveniles, and when we do, it's for tremendously serious crimes, and it's usually used to corroborate an arrest. Almost 3 out of 4 of our incidents are for gun arrests. So why are we collecting that DNA? Ultimately, to corroborate that gun arrest. But what that also does, it contradicts also, right? So if there's 4 individuals arrested on a gun arrest, that could prove that one person had it, but also disprove that other individuals have it. So it works in both fashions, but just when we do collect this DNA, it's tremendously, it's either a gun arrest or predominantly a violent crime or a violent sex crime. So it's very rare, but when we do, we certainly have a purpose. It's far from a fishing expedition.
And if I might just add 2 more points on that. One, really just to crystallize what Chief Petrie was saying, looking at over the past 4 years, right, 90% of juvenile abandonment samples were associated with a violent felony arrest. 99% were associated with a felony arrest, which speaks to Chief LePetrie's point. The other thing that I think is really critical is just to say that when we take a DNA sample, right, DNA can be powerful evidence of guilt. It also can be powerful evidence of innocence, and it can have a tremendous effect in terms of eliminating someone as a suspect and proving that someone did not commit a crime. I think that, and it cuts in both directions. We're talking about incredibly serious crimes. We obviously have an obligation to do what we can to try to achieve justice for victims, to try to figure out who committed sometimes heinous crimes. And sometimes getting that DNA sample, it might implicate someone as having committed it, or it may exculpate them, and that's critical too. So it does cut in both directions.
So just so that I understand correctly as well, in terms of the length of time that the DNA samples are in the database, when the individual is exculpated, does that sample get immediately discarded? I mean, they're like...
Right. So there are 2 different things going on. There's always the option for someone to go get a court order to be removed from the database. That always exists. We also have, on top of that, a separate process that we put in place several years ago, basically to be sort of continuously, essentially reviewing what's in the database to see whether there should be removals, right? So the way it works is we first, in 2020, did a review of everything in the database. Then, for every sample after that, after 2 years, we review it, right? So there's a sort of a look back in 2020, then every sample that comes in every 2 years. And then in 2024, we did another look back for all samples that had been there more than 4 years. So it's a long way of saying that we're sort of there's a continual review process that is going on, both on a one-off basis after a sample has been there 2 years, and every 4 years, a larger look back. And then what are we looking for? So the vast majority, the overwhelming majority of samples in the local database are of individuals who have been convicted of a felony or penal law misdemeanor. And in that instance, they otherwise already have a sample in the state database as a matter of state law, right? So that's the vast majority of the samples that are in the local database. They're actually also in the state database. They're already there. We just have it in a local database because that search will be quicker. Then you have a much smaller number of individuals where basically the investigation is ongoing or the case is pending, right? So there are situations where the case hasn't been resolved. Either the investigation is still happening as we speak, or someone has been charged, but the case is pending, right? So those samples will be there. And then there is a very small number of situations, and this is always in conferral with the DA's office, where the case has been resolved, the person was not convicted, but the resolution of the case happened independent of a determination of guilt or innocence. So for example, if there was a concern about someone threatening a witness and the witness refused to cooperate going forward. Situations in which, yes, the case was disposed of, but there really was no determination of guilt or innocence. That exception does exist. There are some samples like that in the database. It is an extremely, extremely, extremely small percentage of the samples in the local database.
And just for further clarity, I think the public would assume that in the example that was given with regards to a gun, if somebody touches something, of course, if their handprint is on there, that's clear, present indication that that individual touched that gun. If there's gun residue on their hand after their hands are tested and so forth and so on. But if we, so to speak, just have a dragnet of grabbing individuals and maybe only one of them actually has handprints on that gun, I would think that the public would say that it's a long process for 2 years to go by for the review of all of those individuals, if I'm understanding correctly.
Right, but I guess what I would say, Chair Salam, is that we're not talking about a dragnet here at all. I mean, we're talking about abandonment samples last year, 174. That's for the whole city, for the whole year. I mean, every single one of those is a person. I appreciate the significance and the issues that you're raising, but that is a remarkably, extraordinarily small number for New York City over the course of a year. So I think to speak in terms of a dragnet, I don't think that's accurate at all. I don't think it's a dragnet at all. It is actually incredibly targeted. We have policies in place. The data supports this. It actually, particularly when it comes to juveniles, because of the sensitivities, it is actually an incredibly narrow process and an incredibly small number.
What guidelines exist relating to the storage of DNA samples collected from suspects and arrestees? Are samples stored indefinitely, and how does the NYPD use those samples included in the DNA database? I think that might have been kind of answered a bit. But what I'll follow up with is, what policies exist regarding when the NYPD can seek to obtain DNA samples from an individual suspected of a crime but not arrested?
So again, there would be really three different avenues. One is a court order, right? One is consent, and then one is abandonment. And those are all, I will say, those are all three avenues well established under the law. There's case law about sort of the showing for a court order. There's case law about what constitutes valid consent. There's case law about what constitutes abandonment. But those are really the three options.
So in what circumstances would the department seek to obtain a judicial warrant to collect a DNA sample? And when would the NYPD seek to obtain a DNA sample via an individual consenting to provide such a sample to the department, collecting the sample surreptitiously?
As far as getting DNA from a suspect? I'm sorry, I just want to make sure I understand the question.
Yes.
Okay, so I could give you many examples, but I'll give you one example. During a I just want to add the clarifying point of suspected of but not arrested. Right. So there's, like I said, there are many examples, but I'll start with this. During a course of an investigation by our detective bureau for a serious crime, video shows that suspect at the time discarding a water bottle, a cigarette, whatever it might be. That would hopefully be collected by our sharp detectives and then ultimately checked for, against our DNA database. So that's an example. Another example is somebody arrested for a serious crime, a gun arrest, and that person is also suspected of other serious crimes, whether it be shots fired, whether it be a shooting incident, and that person does not have DNA on file. It is an opportunity to get an abandonment sample when that person is arrested, though suspected in other serious crimes, to help us solve, ultimately, that case to get probable cause.
Does the NYPD have statistics on how often DNA samples are collected from suspects by obtaining a judicial warrant? And how many DNA profiles have been obtained via an individual consenting to provide a sample? And how many have been obtained via the NYPD surreptitiously collecting a sample?
Right, so we do have data on that. Let me give you the data for 2024. And this is not juveniles, this is just citywide, everybody. 2024, we collected 2,751 abandonment samples. We had 952 court-ordered samples, and then 244 consent samples. Now, these are all suspect situations, I should add. So sometimes we have what's called exclusion samples. That's different. Obviously, we're not including here samples taken from victims. That's very, very different, of course. And I do want to be clear, these numbers, this is not all going in the database. Definitely not. Only a fraction of this will actually end up in the local database. But those are the numbers in terms of collection from suspects.
How are the policies governing the collection of DNA samples from juveniles different from those that relate to gathering samples from adults? And if there are any different policies, why does the NYPD treat those populations differently?
Well, our policy definitely distinguishes between juveniles and adults, and for obvious reasons, because they're juveniles, and we are very, very sensitive to the age issue. At the same time, we're trying to solve incredibly serious crimes. We have a responsibility to do that with the legal tools at our disposal. I think the two crucial distinctions, there may be more, but when it comes to DNA collection, one, we have a policy that restricts off the bat our ability to seek DNA from juveniles. I sort of gave the criteria earlier. We don't have those same criteria for adults, but we have those criteria for juveniles. That's critical. And then also, when it comes to juveniles, we're talking about in the interrogation context, our officers, our detectives are required to make best efforts to contact parents, legal guardian. They have to do basically everything in their power, reasonably so, to have a parent or a guardian present. And our policy says that if you have a parent or guardian present and they say that the DNA is not to be taken from that juvenile, that's it. We're not allowed to take it. Even if the juvenile says, fine, you can imagine a situation in which a 17-year-old says, yeah, I'm fine with this. If the parent or guardian says no, it's no. So we do have very different rules. And I should add, Chair Salam, there are also a host of other rules when it comes to juvenile interrogations more broadly, how they're conducted, rules in terms of recording and the room in which there are lots of other things, but I think that's the answer to your question in terms of DNA samples.
Does the NYPD inform an individual of their rights to refuse consent when the department is requesting that an individual voluntarily provide a DNA sample?
Absolutely. We are required to do that. We do that. We have standard language that we use. There used to be a hard copy form. We now have an electronic form. And it's quite fulsome. They are informed of their right to decline. They are informed that this sample could be entered into the local database and compared against other DNA samples. So the answer to your question is yes, absolutely. And to be blunt, if we didn't do that, the consent would be no good. There's no question about that.
What percentage of DNA samples collected from minors without a warrant have been relied on in an investigation leading to a conviction? And does the NYPD have data on the specific types of crimes for which individuals have been convicted due to investigations that relied on DNA samples collected without a judicial warrant?
I'm not sure. I don't think we have data on that. If the question is, has DNA collected via abandonment or consent rather than judicial order helped us solve crimes? The answer to that is absolutely. And there definitely have been situations in which that sample has been key. And being key for inculpating someone, also key for exonerating people. But in terms of data lining that up with convictions, that we don't have.
Thank you. I'm going to pass, I'm going to come back with more questions, but I'm going to pass it now to Deputy Speaker Ayala.
I just want to piggyback, good morning.
Good morning.
It is still morning. I want to piggyback off of the chair's question. If you're not tracking how many of the samples are connected to an actual arrest, then how do you know that it's 99% of the time?
It's 99% of arrestees. So we get DNA, the DNA samples that we've taken from juveniles, it's 99% for felony arrests. So out of all our DNA samples over the past 3 years of juveniles, it is connected 99% to a juvenile felony arrest.
Yeah, and the vast majority of the DNA hits are what I spoke about earlier. You know, that connection to the gun arrest. That corroborates the arrest that we already have. So just to bring you to a world, it's approximately 40 or 50 in 2024, but that's the world we're in. You have to remember how little, it's so rare that we collect this. So to have even that amount of hits that corroborate these arrests, and like we said, that also exonerates so many individuals as well.
Also, just sorry if I may, I understood Chair Salam's question a little bit differently, and maybe I misunderstood. I thought he was asking about sort of the link between that DNA sort of resulting in the conviction. That we don't have data on that, and that it would be a harder thing to have data for. In other words, you would have to do a sort of a case-by-case analysis. Did this DNA collection sort of make the difference? I'm not saying it's impossible, but you can see that would have to be very much a case-by-case analysis. It would be much harder to pull data on that.
So you mentioned that in 2024, there were 174 non-consensual DNA samples that were taken. Do we know how many of the 174 were actually convicted of a crime?
That I don't have, though we may be able to pull that for you. That I don't have here, but I think we're going to go back and we can see if we can get that.
That would be really critical information
Sure.
to have.
Understood.
Convicted of a crime, any crime, or the crime
No,
from the abandonment?
From that abandonment, from that particular sample that was taken.
Like the commissioner said, we could, but again, you know, a positive DNA result is a lot of times a piece of a puzzle, which means it's part of the arrest process, ultimately leading to a lengthy court process. It's also a lot of times that we will collect DNA from a crime scene, get a profile, get a donor, comes back to an individual, and that still has to be investigated with a conferral to an assisted, an ADA, things of that nature. It doesn't mean that, right away now we have probable cause because we know who's that DNA. That's not accurate. We actually have to confer with an ADA and then ultimately get probable cause to make that arrest. Just want to make that clear.
Yeah, and that time to crime, to conviction, that could vary, right? That could take anywhere from several months to several years.
I mean, I'm asking because you've stated time and time again that 99% of the time that you're collecting a sample, there's an arrest.
Which is,
And
Yes.
so that's why I'm asking these questions. I mean, I've said it before, I don't have a problem with, and you know, I don't want to ever be put in a position where I am getting in your way of being able to solve a crime. I've been on the receiving end, you know, I've been on both sides, and I understand how difficult it is to have, you know, something horrific happen to your family and want justice. And I respect that. I respect that. What I don't respect is the process, right? Because if you're able to get a court order to get a DNA test, then why not just get the court order? It seems simpler, right? From the way that I'm looking at it with my untrained eye, is that the NYPD is saying, I don't feel like going to court to get this because I'm not sure if this person did something or not. I'm just gonna collect it and I'm gonna see if it, you know, if when I put it in the database, it's a hit. If it isn't, you know, which to me is just, when it relates to young people, that bothers me. We had a case here, as a matter of fact, I was looking at it from, and interestingly enough, it happened in my district, where we had a 22-year-old that was riding around with a 17-year-old, and I guess that there was the police stopped them and they both ran out of the car, but they collected the kid's DNA. His mother, why am I on the clock? His mother, the deputy speaker can't be on the clock. His mother was called, she came to the precinct, she was there, and they never allowed her to see her son, and he gave consent, I guess, under what he felt was like, you know, he was obligated to do that. And the court found that was against the state protocol, right? It violated the state law. So I'm just a little confused about why we need to collect this way.
Sure. So a few things. First of all, I do want to say we don't have it today, but we're gonna do a data poll to see if we can answer your question on the data. I understand what you're asking. I'm sure we can get you some data. It may not answer all your questions, but I think we can at least in part do that. I think it'll be helpful. Second, the case you just described, I'm not familiar with it. I can't speak to that in particular, but I think as you were observing, to the extent you have a juvenile who's being questioned, the detectives are under a legal obligation to make best efforts to contact a parent or guardian. To the extent a parent or guardian showed up and was kept from a juvenile, that's not supposed to happen. It's not like the court recognized that and acted accordingly. That violates the law and it violates our policy. Now, in terms of your question about why not always get a court order, there are times when we are not yet in a position to say we have probable cause, right? So a court order requires probable cause. And there are times when we don't have it yet. We're investigating, and we're seeking consent, or we're taking an abandonment sample. An abandonment sample can be from the field. It can be sometimes from a station house. And we're doing that because we're trying to solve the crime. And we're trying to achieve justice for victims. And I totally understand what you're saying when we're talking about taking DNA from a juvenile. There is a countervailing concern, which is if you have a victim, someone who was shot or raped or assaulted, and we have an opportunity consistent with the law to solve that crime, potentially solve that crime. It may not work. They may not have done it, to your point. We could be wrong. The suspect doesn't mean we're right. We're not right every time. But if our detectives have an opportunity to take an investigative step that might solve the case, I think we got to be really careful about saying they can't do that, or certainly saying they can't do that in all circumstances. I do think there are countervailing considerations here. There's the concerns you're raising about juveniles and privacy. There also are concerns about victims and justice for victims and wanting to solve cases.
So we have two kids that come in a scenario like this one. One, maybe one was guilty, one was not. We don't know. You have a kid under the age of 18. Is the first step in that process of interrogation and, data collection to call the parent of that 17-year-old?
Absolutely. So again, this is both our policy and it's the law.
Okay.
It's the law, state law. We are obligated to make best efforts to try to contact a parent or a legal guardian.
And what is the purpose of calling the parent or the legal guardian?
So they can come and consult with their child.
So in 99.9% of those cases, the parent is allowed to speak to the child.
Yes,
Before
absolutely.
they're consenting.
Absolutely. Yeah, this is not just like, it is our policy, but it's also state law. We don't have a choice. Now, there
No, because
are...
in this case, the NYPD did call the parent. The parent came to the police station, but the parent was not allowed to talk to the child.
Yeah, and again, I can't speak to the particulars of this case. I don't know this case. That sounds all wrong. That sounds all wrong. That is not what is supposed to happen at all. And it sounds like procedures weren't followed, it wasn't done the right way, and the judge threw out the case. Now, there are situations, and I should add, by the way, one thing we're very clear with the detectives time and again is you have to document these efforts, right? There will be questions after the fact. Did you, in fact, try to contact the parents? Did you make best efforts? There are situations in which detectives try to do that. They are unsuccessful. Either they can't reach anybody. There are times when they do contact someone and the person doesn't engage, doesn't show up. That does happen. And in those situations, if they have made best efforts and there is still no parent or guardian who is coming to speak with the juvenile, then yes, the detectives will go ahead and question that person. They will. It'll be recorded. It must be recorded. There are no exceptions to that. Absolutely all juvenile interrogations must be recorded, no exceptions. But yes, if best efforts are made, if they're unsuccessful, will the detectives go ahead and conduct a recorded interrogation of the juvenile? Yes, they will.
Okay, so now let me switch it a little bit. So the parent comes in, the parent says, no, I'm not consenting. The child says, no, I'm not consenting. Would you still collect the abandoned property of that person?
So the answer to that is that should not be happening. It should not.
That's not an answer, though.
No,
Is it a yes or no?
but I think it is an answer. I'm saying this, the reality is, in a scenario in which our policy does not speak to that. That's why I want to answer your question honestly and accurately. Does our policy directly speak to that scenario? No, it does not. But I'm telling you, right, in a situation in which someone has affirmatively said, I am not giving consent, an abandonment sample is not going to work. It is not going to work. If we have gone the consent route and that has failed, then taking an abandonment sample is not going to work. Given that someone has affirmatively said, I do not want my DNA taken, right? An abandonment sample is not going to work in that situation.
But you can't guarantee that doesn't happen.
Well, what I'm telling you is that from a legal perspective and from the department's perspective, an abandonment sample is inappropriate in that situation. Can I speak to whether that has ever happened in the history of time? No, I can't speak to that. What I am telling you, though, is what is the department's position on that issue? And the department's position is, in a situation in which consent was requested and consent was denied, to then, after that, seek to take an abandonment sample from that person, that abandonment sample is not going to be legally, it's not going to work legally when someone has affirmatively said no, and that should not be happening.
Do you know how many of the 174 non-consensual DNA samples that were collected in 24 were for minors?
We're from?
For minors?
Yeah, we have that.
That is the minor number. So
Those are all minors, the 174?
174 under the age of 18, yes.
Okay, so
That's
all,
6% of all the abandonment samples taken in 2024.
okay, but all the parents for those 174 were called.
It is, I think the commissioner spoke about it a couple of times. It is mandated through NYPD policy and state law that we have a documented attempt, multiple attempts, to get in contact with a parent or legal guardian of a juvenile arrested under the age of 18.
I'm just trying to figure out why the need to collect these non-consensually. So 174 is 174. It's still, it may be 6%, but it's still a substantial number to me.
I think I got to put some data and context into this.
Yes.
Again, these are 99% of these abandonment samples are for felony arrests. Some data, we know a quarter of juveniles arrested with a gun just a few years ago, within 2 years, they're going to be involved in a shooting incident in New York City.
So you hold the DNA test, the DNA sample just in case?
That's not what I said.
That's what it feels like,
I'm just giving you some
That's
data
what it feels
behind
like.
it.
It feels like lazy policing. It feels like, you know what, I don't have enough information, so I can't go to court and ask for a court order because the judge is gonna tell me that they can't give it to me because I don't have any evidence to suggest that this person committed a crime. But just in case, I'm gonna collect it, and the law, there's a loophole in the law that allows me to collect it anyway, so I'm gonna collect it and I'm gonna keep it in storage just in case this person commits a crime.
It's not
today
lazy
or in 5
policing.
years. But that's
It
how it
is
sounds.
not. It's not lazy
It's
policing at
actually
all.
the opposite.
It's trying to solve crimes. And yes, when detectives do not yet have probable cause, they're using investigative steps to try to figure out who committed very serious offenses. One of the tools at their disposal is to obtain, sometimes via consent, sometimes via abandonment, a DNA sample. I don't see what's lazy about that at all. Listen, I agree with you. If we have probable cause to arrest someone, we can go arrest them. And I don't think our detectives are gonna, if they have probable cause to arrest someone for a serious crime, they're not gonna hold back. They're gonna go make the arrest.
And if somebody committed a serious crime, I want you to arrest them. I just want to make that clear.
Right, but we have to figure out who did it. And we have to figure out,
I respect that too. I get it. I just want to know what I am trying to do with this bill is to prevent young people. I think that there's a cultural disconnect. The way, I was raised in the Lower East Side in Lillian Ward houses. Most of my friends were considered gang members, They get labeled because they're affiliated with someone. You have kids that, are looking to fit in somewhere. Many times, I was in an apartment where there were drugs, where there were guns. I never committed a crime. But that was the environment that I was raised in. That was it. I didn't have, those choices. I walked in and I walked out. I want to make sure that young people that are not guilty of anything are not having their database stored. I don't, because I think the chair asked about how long, you carry that, how long you store it. And you never said that you throw it away, right? You said in 2 years, we're going to look at it. In 4 years, we're going to look at it.
I mean, every 2 years, there's a review of what's in the data. If any sample that's been in the database for 2 years gets reviewed.
Yes.
There's a separate, every 4 years, a larger look back. But I just want to go back again. I understand what you're saying in terms of concern for a juvenile's DNA being taken. I get that.
And innocent.
But that's the question. Is the person innocent or guilty? We don't know. We have a suspect.
We don't know.
And if we have, let's say, a homicide, right? And we think this juvenile 17-year-old, they committed this homicide, right? We do not yet have enough to make an arrest. We don't have enough. We don't have probable cause. But we think that getting a DNA sample could make the difference. It might, if that sample comes out one way, we're gonna have enough to make the arrest. If it comes out a different way, the person may even be exonerated.
So let me ask again, out of the 174, all of those 174 were arrested for that crime that the DNA sample.
Almost all. I think we had 99%.
Of the 174?
Yes, we had 99%, we had a felony arrest.
It is such a minute, very, very rare occasion that we would be collecting a juvenile's abandonment sample prior to an arrest. Very minute.
Okay, so what is your position on the bill?
Our position on the bill is that there should be a very narrow carve-out, that it should be only permissible, and consistent with the bill, right? We're talking about pre-arrest situations. Your point. We're not talking about DNA sort of from a crime scene, but pre-arrest. It would bar collection from juveniles, absent consent of a parent, guardian, except a narrow exception for A or B violent felonies, which is not a long list, and it's incredibly serious crime. We're talking about murder, rape, kidnapping, that sort of thing. So it has to fall within one of those categories. The person's a suspect for one of those crimes, and authorization from the chief of detectives. Right? It's not just a detective in the squad decides, hey, as one of the times, you have to go to the chief of detectives and get permission, and then we'll track it. Right? There will be a record. The chief of detectives, him or herself, authorized this collection. I think what we're trying to do is really to balance here. To a very large extent, you know, the bill will restrict us, right? There will be a universe of felonies where we would otherwise potentially be seeking to take DNA, and we won't be able to anymore. But to have that narrow carve-out for the most serious, violent crimes with authorization from the chief of detectives, we think that is an appropriate balance.
All right, well, there'll be some time, I guess, for further discussion, but do you know what the circumstances were that led to the 174 cases of abandonment samples from kids?
I'm sorry, could you just ask that again?
What were the circumstances around surrounding the that led to the 174 samples of abandonment samples collected from kids?
When you say circumstances,
What are the circumstances? How does like?
I'll reemphasize a point I made earlier. They're really to corroborate a crime that an individual was arrested for, right?
Yeah.
Like a gun arrest. You know, the vast majority of those are collected, so this way we can compare it versus that recovered gun. And once again, it not only corroborates the arrest, but may exonerate another individual.
And if I can, again, last year, there was, and this is just gun arrests.
Yes.
There was almost 500 juveniles arrested with a gun last year in New York City. That's 12% of all the gun arrests, and we only have 174 abandonment samples. That's just gun arrests. I'm not talking about the 100 juveniles that are arrested for shootings last year. I'm not talking about the thousands that were arrested for robberies. So 174 abandonment samples, 500 gun arrests, almost 500 gun arrests. 12% of all New York City gun arrests under the age of 18.
Yeah. I mean, I see it in my community all the time. We just want to make sure that the process is fair. We're not saying you shouldn't be collecting DNA from a person that committed a crime, but I also don't believe that we should be storing DNA samples of a young person who hasn't been, convicted or arrested for any, for a crime. And, in the same case, you say it works both ways. Once that sample is collected, if, assuming that it was collected with consent, and we find that that person, is not in fact, that person's DNA should be removed from the database immediately. That's all I'm saying. So I'll leave it at that. Thank you, Chair.
Thank you. I want to turn the next set of questioning over to the public advocate.
Thank you, Mr. Chair. First, I did want to make sure we're clear, because I know sometimes people confuse these bills and these questions as people not wanting safety in their community, or sometimes being opposed simply to the police, when actually there's just a false binary that's put in place that the way to solve this is simply just trying to arrest and use law enforcement. And one of the reasons I do this work is because when I was younger, there's a number of people I can name who are no longer here because they were shot and killed. Unfortunately, when I speak to young people now, they also have a list of people that are no longer here because they were shot and killed. And so if the type of policing that we're talking now was supposed to have worked, they should no longer know those names. And so it is frustrating to me that we still have these generational issues that don't seem to be addressed, even as we talk about these things. I did want to add a statistic that we discussed, to the statistics we discussed about the percentage of individuals who are arrested for shootings and victims, 96% people of more color. 84% of the people who are released wrongfully convicted are also black and brown, which means the system is not working that way either. I did want to also point out, because I heard the words, the police will be, their hands will be tied. I've heard that a lot of times for bills that have come out of the council. I just never seen it happen. So when we passed the Community Safety Act, when I was in the council, I heard the same thing. We went in about an 8-year trend of becoming the safest we had ever been in the city. If you remember a few months ago, all hell broke loose, World War III, when we were trying to pass How Many Stops Act. The world would crumble then as well. And I'm now hearing about numbers getting better and becoming safer, even with the How Many Stops Act. We've even had reports that have come out that no one is talking about. So those, I hate those terms because they always make people think we're trying to do things that we're not, and they never have come to fruition. But with that, I did want to ask if you had data on your clearance rates for murders and shootings before and after the database.
Which database? The
gang
DNA
database.
Or the criminal group database. I'm sorry, which database?
The clearance rates of solving murders and shootings before and after the database.
Are you referring to the DNA database or the criminal
The
group?
gang, what we refer to the gang database.
Well, it's consistently been approximately 65% to 70% clearance rates for murders, and it's consistently about 45% on shooting incidents.
Yeah, we're on pace. Well, last year was our second best year, and the year prior was our best year ever with clearances. So declaring those motives certainly contribute to that.
And do you have similar data for prevention of retaliatory shooting?
Yes, I mean, so we're shifting to the criminal group database?
No, this is the same gang database. Yes.
Yes. We're in DNA, now we're shifting. Okay, let me just start with this. You know, last year was the safest year in the history of the 30 years of CompStat, where we started accurately recording crime statistics in Brooklyn. Brooklyn, safest year in 30-year history.
Does the database only exist in Brooklyn?
No, but I'm gonna, if I can finish, I'd appreciate it, thank you. A large part of that was precision policing, using our investigative precision and our deployment precision in neighborhoods such as East New York, Brownsville, Bedford-Stuyvesant, Crown Heights, East Flatbush. And the criminal group database was a part of that, knowing instantaneously where a shooting was in the Vanderveers in East Flatbush and moving resources as far as Far Rockaway in southern Queens, moving resources to Brownsville, Brooklyn, East New York, Brooklyn. And how do I know that? Because I'm a large part of that. It's about deployment. It's about precision. It's about looking at the trigger pullers in New York City and putting it all together. Lincoln's analysis, connecting guns, connecting crews, connecting territories. Long and hard work for our
So
investigators.
I'm running out of time. That's the only reason I'm going to interrupt. But it sounds like you're able to do that even with the bail laws and the How Many Stops Act.
Your question was not.
No, I was just asking that. That's happening. But that's happening at the same time as the How Many Stops Act and the bail laws and discovery. Correct?
Sir, you know what's happening?
Wait, no. Is that correct?
If I can answer the question.
Yeah, but I'm out of time. I just want to know if that's correct.
26-year high in index crime arrests.
Got it. Okay. So the
4,000
reason
gun arrests.
I will say, if you ask the Brooklyn DA, he will talk about the programs that he had that was precision as well, that directly spoke to the people who were most likely to be shooting, and were put in the programs that prevented that.
That's not
so,
that's
but
not-
I'm going to say, that's why I asked you if it was happening only in Brooklyn, but apparently it's happening in all the 5 boroughs, but you haven't had the same results.
Yes, we have.
In all the 5 boroughs.
We have, and I'll
Okay.
give you another example.
Okay, but so.
Do you want me to give you another example?
I don't have time. Is the
Because I
only
could
problem.
move to Manhattan.
But the only thing I wanted to say, ask was this: with all, because we agree, I think that people who have been arrested for shooting are likely to be shot, or be involved in shootings, which we all agree. Any of this
Wait, I'm
information?
sorry. I didn't hear that.
There's something you said previously.
People likely to be shot.
Young people who are arrested with guns are likely to be involved in a shooting at some point.
Yes,
before.
that is accurate.
We all agree. So those are the folks we want to focus on. But my question was, does any of this information get shared with other? Do you have other agencies that you speak to? They say we have some folks that might be in some problems. If we can get involved sooner, that we might be able to help them.
Absolutely.
What is that?
Commissioner Gerber spoke about the community aspect of it.
No, I didn't hear that being talked about, so maybe you could talk about.
I'm sorry, I just want to make clear the question. Are you asking about the criminal group database information in particular, or more broadly, youths at risk? I just want to make sure I'm answering your question.
So I mean the database specifically, but I had more questions on one time, so I'll wait for the second round. But I did want to know if in that group, are we talking with other agencies about how we can not use law enforcement as arrests to try to solve?
So I want to try to answer your question, part of which really maybe go to Commissioner Foster's work. But there are two separate things. So if you're asking about, is there work that we do with various city agencies in connection with young people who we think are at risk? The answer to that is yes, absolutely. And our Community Affairs Bureau and Commissioner Foster's team does a tremendous amount of work in this space. When it comes to the criminal group database and who's in the database, it's very, very different. And for reasons I hope you can appreciate, we actually do not just share with other city agencies, oh, here are the members of our criminal group database. We don't do that.
I know.
And you know why.
Yes, but I was going to say, you can share it without saying that this is where they came from. But I don't have any more time, so I don't want to take up. But I want to be clear that when we talk about precision policing or others, nothing has shown that this particular database has helped us get to where we want to go. So I do hopefully in the next round be able to talk about that a little bit more specifically.
I would love to do that. Thank you.
Thank you, Public Advocate. I'll now like to turn it over to Councilmember Stevens for her questions.
Hello, how are you guys doing? Good afternoon.
Good afternoon.
I mean, you guys have made it very clear that you guys don't like my bill, unfortunately. But there was something that you even said in your testimony, and even the public advocate just mentioned it, because you said 96% of the individuals arrested for shooting were African American, which is why it's reflective of the database, which is why the data is more looking at African Americans specifically in the database. That's why, because that's where all the shootings are happening, correct?
No, actually I said it was people of color. It's not just African
All
American.
right, but mostly, because we know that the numbers are even skewed there. But mostly, correct? And African Americans, people of color, but it's mostly black and brown, correct?
In the database?
Yes.
Yes, that is correct.
And most of the people are doing, those individuals you're saying are doing the shootings, correct? Because you said 96%.
Two separate things. I gave the data about the racial demographics in the database. Separately, I gave data about the racial breakdown of people arrested for shootings and shooting victims in New York City over the last several years.
But you said it was like 96% because it's here.
Yes, no,
okay, it's like
I did say that. 100%.
So then my question is, how is this working? Because that to me shows that if you're saying you are profiling these people because it's racial profiling, and then still those same people are still doing the shootings, how is this working?
Councilmember, first of all, it is not racial profiling, and that is very unfair. The data I gave you is about individuals arrested for shootings and shooting victims. There is nothing racial profiling about that.
No, I'm asking.
It's not.
No, listen to me. I'm not talking about the shootings. I'm asking you, the folks that you're observing, if the people that you're watching and have on the database are still, you're saying, are mostly people of color, and all this is happening. How is this working? Can you give me data on how many shootings this has stopped in those communities?
So we're going to give examples of situations in which the criminal group database. And
no, I want numbers. I want the numbers around what percentages of shootings that this has stopped. Because my issue is around, if we are saying that this is about making things safer and you're using it for ComStat and all these things, how is it making it safer if these shootings are still happening? And like, how?
Okay. First of all, I would love to stop every shooting in New York City, but we know that's impossible.
Well, that's going to be our goal. Let's work together on doing that.
I would love to. I would love to. So you're talking about, give me an example. So let's take, again, we'll go back to Brooklyn, right?
I don't care about Brooklyn. I'm in the Bronx. Go to the Bronx.
I'm going to go.
No, go to the Bronx.
We'll go to the Bronx.
Because I'm not in Brooklyn.
Okay, so we'll go to the Bronx. I'll give you an example of the Bronx. Then I'll go.
And you guys know I have time. So while you're
I'll go
going
to Southeast Queens. We'll go.
All right, get
community by
to the
community.
story, please, because I don't want you to eat my time, because I actually have some more questions.
So I'm going to give you an example of the criminal group database and basically how it works.
But could you give
So
an example?
I am giving you an example.
Yes, please.
19 incidents of violence in the 4-0 precinct connected to multiple crews. One of the crews, which I will not name, has documented 45 members in the criminal group database. 19 acts of violence, that's either shootings, people shot, shots fired, or gun arrest in a 2-month frame, right? We noticed younger individuals that were tied to older individuals that were. I'm
going to stop you because I didn't ask for that. I asked for the numbers and the data. I didn't ask for a story or anecdote, because if we are saying it, I'm asking you, how is this with the data that you have? Because this is about data and making sure we're using percentages and things like that. So how is this data stopping crime? What is the percentage of crimes that this database has stopped?
Wait, Councilmember Stevens, you know that it's not possible.
Exactly.
No, hold on,
So let's stop there.
hold on.
No, because I have
Asking for
another
data
question.
You're asking for data about a negative. You're asking for data
All right.
of shootings that didn't
So
happen.
just say you don't have it.
No, because that's not the case.
Because you say
it's that you're asking for data that you know could not possibly be generated. You're talking about interventions that will prevent shootings, that do prevent shootings. But there's literally, it is not possible to track shootings that didn't happen.
Could I just
and you know
interject
that.
there, because it's not even, because there's no interventions that's being done. Because it's one thing if you were saying that you were using this data, working with DYCD and all these people, because you also said you're not sharing this information. There's no interventions being done to stop anything. So no, because that's true, because I asked you that offline. You're not doing interventions. And so if there's a difference, if it's like we're using this information to actually bring resources to those communities, meet with those individuals and find the things that those families need, that is very different. There's no interventions. And let's also be clear, when you're saying resources, you're saying cops. That is not going to get us out of the situation we're in. I don't want to stay there because I have some other questions. So have you ever heard of the Ghost Shadows? Have you ever heard of the Ghost Shadows? Because that's a well-known Chinese American gang that's in New York City. Are they part of the gang database? Because I know you have 560-something crews in there.
500.
Have you heard of the 5 families? Are they part of the database?
Councilmember, as you know, there is a separate database.
No.
Hold on. I'm answering your question. There is an organized crime database.
But this is not organized crime.
The ones the 5 families.
No,
that is organized crime.
Ghost Shadows, that's not organized crime. That is a New York-based gang that is in Chinatown. Are they in the database?
Councilmember, there is
Because they are
a group database. There is also an FBI database, which our TFOs are able to, working with the FBI, and draw on that.
I'm asking you about a New York-based Chinese gang that's in New York. Because in your database, they're only what I think I have the numbers. What is it? There's only like 70 of them. So is that the gang that's in there? Because I'm asking you a real question. Because again, I am saying, and why I get so upset and passionate, because you guys are willing to go so hard around something that I do not feel like is moving the needle. But it would move the needle in changing your relationship with my community. It's not. And I think that when you're in other communities, you're able to not have databases because crime is going on in other communities. And so how are you solving those crimes? Those crimes are happening, but you don't have to have a database to say like, oh, let me go in here and see if they're in here. No, you're solving those crimes. So even if you don't believe that you could do the work, I know you could do the work.
Councilmember?
And it would fix the relationship, I promise you.
2 points in response to your questions and your statements. First, do we share information about membership in the criminal group database with other city agencies? We don't, and you know why we don't. Because if we did, the city council would be outraged, and you would be upset with us, and you would say that it is stigmatizing. So to suggest that we should be sharing.
No, I want to be
wait,
clear.
hold on.
No, because I didn't suggest it. I said there's no intervention. So you're collecting the information because here's the thing. This is not stopping anything. Because if we were getting these young people off the street and putting resources there, that's how we stop the crime.
I want to give an example, Chief LaPage, give an example of where we save lives by intervening.
These are lives.
These are lives saved.
I'm going to give you an example. On January 13th, members of the NYPD were deployed in a specific area precinct in northern Manhattan, the 3-0 precinct, in regards to an uptick of crew violence. With that deployment, built on intelligence from the criminal group database, officers are deployed. Officers were able to effect the arrest of 8 individuals with 5 firearms. 2 of those individuals arrested with the 5 firearms. One of them was an identified crew member from a housing development in the 2-4 precincts. Another individual, identified crew member in a criminal group database, crew member in the 2A precinct in a housing development. That one of those guns was previously fired just a day prior in the 3-2 precinct. So what does that tell senior leaders of the NYPD. It tells us where to deploy. Hence, we
So
deploy.
you're saying that
Wait,
that
let him finish.
No, I'm
Please.
asking a
Please let
question.
him
I'm
finish.
asking a point
Please
of
let him
clarity.
finish.
I'm not.
No,
am I finished?
no, I'm asking because
Okay,
you said that the. Let me finish because I'm asking the questions. Don't do that. I'm asking a question because I'm gonna forget. So you're saying that they were deployed specifically in that area because of the gang database?
Absolutely. Part of it. Absolutely.
Part of it, or is that the reason why?
Part of the reason.
Exactly.
You
You have other means to get to those places. You know where the violence is. You know where they are. And that's all I'm saying. That is one piece that is not necessary. So please do not sit here and make it seem like if this is not here, the sky is falling. Because guess what? Like you said, there is other parts of it and intelligence that you are using because you know where the crime is happening. You know, you do.
You're missing the point again. You're not listening to my answer. My answer is that 2 of the individuals were documented crew members in 2 different precincts that we would have not known to deploy there. And if you let me finish my statement, I'll continue giving you more examples. So what does that tell us? That tells us where to deploy and what crews are beefing. Then what do? Then we continue to analyze the intelligence, like the 5 guns that we were able to recover because of our deployment. What do those 5 guns tell us? They were fired 4 different times in different locations in New York City. So now we can start connecting. That gun belongs to this crew, that gun belongs to that crew. So then now there's 4 more commands that we deploy to. Fact, the 2-8, the 2-4, the 3-2, and another command in Manhattan North. I'm sorry, the 3-0. So 4 commands. Since we moved deployment, since January 13th, 1 shooting. 1 shooting in those 4 commands. 1. That is because of intelligence precision. So a part of it, the NYPD hits on the guns, a part of it. Who we're arresting is part of it. The crew alliances are part of it. The crew identifications are part of it. Moving officers real time, not waiting. And that's how we save lives. Part of it is using the criminal group database.
Part of it.
Yeah.
And that's what I'm
Everything's
saying.
a part.
You guys have a
Police-
lot of other tools that could be used. And that's what I'm saying. We're saying the same thing. I know you have other tools. And I know that you use other investigatory ways. Obviously, if there's a shooting. But what I'm saying is there are other tools that you should be using, especially when this is it's clear evidence that this is racial profiling when 99%.
This is not
racial
this is
profiling.
Precision. This is precision.
We can't just change
And
language.
we're able to give you data because of the database. That's how you get your data. If we didn't have a database, you wouldn't be able to get data. But we do
Councilmember,
have a database, and we can give you data.
With your permission, I'll just go, and just because I think it's worth telling, just go into the culture of gang shootings, right? We know they're contagious in nature, and they rarely stop at one. They become contagious, and we need to stop that shooting cycle. How do we do it with rapid deployment? Now, what a gang shooting does, it creates an on-site environment. Now, what is that? When you have a gang shooting, you have both teams now that are carrying a multitude of guns. You have the oppositions carrying guns, and you have the aggressors carrying guns. All are expecting violence, and they'll shoot at each other the moment they see them. What does that mean? On site. That hence the term. Now, that creates such a dangerous atmosphere, and it's just so time sensitive. Why? Especially now? Because of social media, right?
My time is up, and I don't want to be disrespectful to the chair, and I know that they so, but we'll continue to talk, but I just want to be clear and just say the last thing is, like, there are other tools that you guys are using that are actually solving the crimes, and you guys are being clear about that. And so the sky isn't falling, and I think Jemani, our public advocate, said it. Every time there's a situation that you guys don't like, you push back so hard and make it seem like the sky is falling. I actually have faith that the other tools that you're using is going to be better than this, because it's about restoring the trust that needs to happen in the community. Because unlike, I live in this community still currently. Like, I didn't move away. I live in the community where we have some of the highest shooting in the city. I live there. I see it. I've worked with kids who've had to bury their friends. We are not doing the real work. And to me, this is a place where we could actually recreate how we are community policing, and this isn't it. There's other tools. And so we'll continue to talk. Thank you, Chair.
You're welcome. I just want to make sure some of the stuff I heard so far is concerning beyond the subject matter of what we're talking about today. And it's concerning because without the introduction of studies like what happens when you add abject poverty to abject poverty and what conditions it creates. We know that when people are in desperate situations, of course, you know, as they say in the streets, if you got food on your plate, I'm going to find out how to get that food off of your plate, right? And so the challenge of being able to restore balance in a society where there's a great amount of people who do not have because they're in abject poverty causes the situations that we're trying to fight with tools that might not necessarily be fully adequate, according to what I'm understanding Councilmember Stevens to be saying. I'd like to also recognize that we've been joined by Councilmember Vernikoff, and I want to pass the next set of questions over to Councilmember Caban.
Thank you. I just want to start with a couple of comments. One on Deputy Speaker Ayala's bill. I keep hearing about these exceptions for alleged serious crimes, and constitutional rights are constitutional rights are constitutional rights, and especially when we're talking about young people. I don't care if you were charged with jumping a turnstile or charged with murder. Those constitutional rights should be protected, and they are not of the right mindset or mind frame to give consent to these different things. There should not be that exception. For DNA, and talking about the need to collect this, I just want to point out, as an experienced public defender who litigated many, many cases, including cases that involved DNA evidence, DNA is not the only way to secure a conviction. There are lots of ways to prove a case beyond a reasonable doubt, and DNA oftentimes is just one of them or supplemental to. And in fact, I have tried cases where the DNA evidence that is presented by the prosecution is used, the type of DNA evidence, the technology is used to say this person did it beyond a reasonable doubt, and then 2-3 months later, I'll try a case and that same DNA evidence and that same technology, the defense finds exculpatory, and the prosecution will be able to make an argument about how that DNA evidence is wrong or off or is offset by these other circumstances. So I also just want to point out to people that these sciences, the sciences that we put in front of our courts, they're not 1,000% accurate. They're not bulletproof. I mean, there's plenty of, I'm not saying DNA is junk science, it is not, but there also is plenty of junk science that we allow into the courtroom. So it should not be the only thing. Moving into my questions, I want to ask, and this is about the gang database, are you aware of any independent peer-reviewed evidence that shows that the database directly contributes to reductions in violent crime? And it's a yes or no question.
Your question is whether we've had sort of, for the NYPD database in particular, where we've done some sort of peer review or academic analysis?
Are you aware of any independent peer-reviewed evidence that shows that the database directly contributes to reductions in violent crime?
I don't think we've done any study of that sort, no.
Okay. So that's because there isn't any. There is not an independent peer-reviewed evidence that has the results that shows that it reduces.
No, we just haven't done the analysis either way.
Have you made any effort to calculate the costs of maintaining the database, including computing costs and staff time to process and review entries? What's it costing?
It's within our enterprise case management system.
So
there's not a separate. It's within the enterprise case management.
If your question is it a significant financial cost to the department, I think the answer to that is no.
Great. Moving on. It's not that hard. Is it true that people in the database are more likely to be subjected to surveillance, including their social media? So, like, if you're on the database, you're going to be watched more closely, right? You're going to look at their social media.
No.
No.
No, I think that's not the case at all.
Okay. So you're saying that if they're on the database, you're not, I mean, that's contrary to what you testified to earlier, saying that you look at the database.
No, it's not. What we said was that in situations in which we are, for example, there's been a shooting, and we're trying to figure out the motive for the shooting, trying to deploy effectively, investigate effectively. Do we utilize database in that situation? Absolutely. The database is a very, very important intelligence tool. Your question, as I understood it, was a question about sort of generalized surveillance. Do we have some surveillance program of the people in the database? And the answer to that question is no.
But you are checking into these people even if there is even though evidence of criminal activity is not required to be entered into the database. Like, you do not have to have evidence of criminal activity to be placed into the database, correct?
Your question is, if your question is, does someone have to have committed a crime in order to be in the database? The answer to that question is no.
And that's,
Okay.
let me just add
And-
to that.
and-
That's 1%
Okay.
of the database, 1%.
Yeah, the vast majority of the individuals in the database have committed a multitude of crimes and a multitude of violent crimes. And that 1%.
Have been convicted of?
No, I'm sorry.
Have been convicted of?
Arrested of.
Okay, so
Arrested.
they have not been convicted of.
I'd
They
have
have
to go
not
into
been
the
proven
data
beyond a
as
reasonable
far-
doubt to be guilty of
But-
a crime. They have only been, so 99% of people have been accused
A
of a crime on that
multitude
list.
of arrests. In fact, a very large
No, I think you've answered my
percentage, we're talking
question.
5
There's
or
a
more,
difference between accused and arrested and convicted.
And that 1%.
I'm going to move on.
I
Thank
could-
you for
I could
answering
give-
my
I could
question.
give you-
I
I
have
could give you
two more, Chair.
prior felony
What role, excuse me, what role do school safety officers play in recommending that young people be added to the database?
To my knowledge.
That could be one of the independent sources that, we consider them an expert of the subjects, right? Like, nobody knows our kids better than our school safety. That could be one of the independent sources.
And so school safety officers are saying, "Hey, I'm around the school. I think this kid's in a gang."
It would have.
That would not,
That's not-
that would not be enough in and of itself.
not
Hold on a second.
accurate.
Hold on a second.
Not accurate.
We have, as you know, we've tightened up significantly the rules for someone being entered into the database. If two independent sources, two independent individuals, say that someone is in the criminal group database, and that's
So
part
two
of
school safety agents?
Hold on a second. As it's two separate independent sources, and
So it could be two.
and
It could be two.
investigator-
I'm clarifying. It could be two
investigators-
school safety agents, right?
two independent
Yes or
individuals.
no?
No, but there's more to it.
You can
And there's an
continue on, but just answer my question.
And
I'm trying to.
I'm trying to answer your question.
Yes or no? Could
But
it
we-
include two social?
And other
safety.
things as well. That alone will not do it.
That was not my question.
It was
It's
your
really,
question.
It's really
It
simple.
was your question.
I asked, could those two independent people be school safety agents? That's
But that's
it.
not sufficient. You're making it like that would be
That's
sufficient.
not my question.
If the question is two school safety agents separately,
Do they count as
yes.
independent?
And if that is
sources?
sufficient, the answer is no. Does that contribute? The answer
That's
is it could
not
be,
what I
yes.
said. Okay, you listed out a few requirements for getting on the list. I am asking you about one of the requirements,
Right.
the independent corroborations, and I said, would two separate school safety agents be that?
You are
And they-
misstating. You are misstating the criteria. It's not.
I'm asking about one part of the criteria.
Okay, so I want to be crystal clear for the record. There is, if someone has been identified as part of an ongoing investigation, and there are two separate, independent, reliable sources,
Okay.
that person is eligible to be entered, potentially
Okay,
entered.
and my question is,
Yes.
for that part of it, that eligibility,
Yes.
can it be to school safety agents?
Two separately,
Yes.
yes.
How hard was that? How hard was that?
Council member,
Thank
you were misstating
Now-
the criteria.
No, I'm asking you.
Yes, you
The
were.
criteria is this big, and I'm choosing to ask you about one part of the criteria. It's not missing anything.
Yes,
I'm
it
asking you
was.
about one part. It's real simple. By the way, I don't know if you know this, but you guys make yourself look a lot worse when you play games with the most simple of questions.
We are not playing games. We are
I'm gonna
answering
sign
your
up for a
questions to
second
the
round,
best of our
Chair.
ability.
Thank you.
Thank you.
Agreed.
Thank you. We will now hear from Councilmember Ariola.
Thank you, Chair. I want to start with a statement. I just want to say that the fact that we're having a hearing on these bills proves how far off the rails we've gone in public safety in this city. Any DNA evidence that is collected is subject to admission in court, correct? Correct. So it does not in and of itself convict anyone. And if the police cannot collect info on criminal activity that would seriously impede your investigation, a prosecution, a conviction, and getting a violent criminal off the street. So I understand why you would be in partial support of Intro 125. I get that completely, but with the carve-out that you've asked for. So you're not being an impediment to improvement. you want to improve. On the gang database, or as our public advocate said, we should be focusing on preventing violence and target at-risk youth with programs, etc. How would we know who these at-risk youth are if we could not identify them and collect information about them? And what should the list be called? Give it a new name. If we gave it a new name, would it have a different meaning to the people on this panel? And I would like to give you a chance to answer a question fully, because you've not been given that chance yet.
So I think,
Go ahead.
and I think I'll turn over to Commissioner Foster, because I think there really are, we're talking here today about the criminal group database, talking about enforcement efforts. There is a tremendous amount of work, an extraordinary amount of work and great work that Commissioner Foster and his team do to try to help young people who are at risk. So turn it over to him.
Yes, thank you, Commissioner, and thank you, Council Member. In the Community Affairs Bureau, we oversee all of the community affairs offices around the city and all your 78 precincts that you guys all represent. We have a number of different programs working with the Department of Education, the Department of Youth and Community Development, the New York City Police Department. We have one of the largest city agencies, summer youth employment programs, where we hire over 1,000 young people in all of our 78 precincts, 9 housing commands, 12 transit districts, and from the police commissioner's office down. And we have a number of different programs that we do to try to keep young people from ever getting into the database, but also getting into any type of trouble. This past Friday, we just, in the chair's district up in the Polo Grounds, we just opened up with DYCD and also PAL, the Police Athletic League, our first aviation program, where we took a pilot from our aviation unit, and he's from the community. He wants to get back to the community, and he's running a program where he's teaching the young people in Harlem the skills and the life career of being a pilot. So we have a number of different programs. We take young people, partner with SUNY. We have over 20 school visits where we partner. We take young people from all over the city to different colleges, building that relationship. A lot of people say, how come the police should be into programming? It's very important for us because we want to be able to build those relationships with the young people. And my men and women of this department have a lot of different resources, talents, sort of like that officer that's running this aviation program. And we also want to show people that the police officers is from the communities that they represent.
Thank you. And in your testimony, Commissioner Gerber, you've said how these lists have been purged and the numbers have significantly decreased with the names that are on these lists.
Yeah, we've made very significant changes. The DOI report came out in 2023. We took the majority of the recommendations, and there were some very fair critiques in the DOI report, places where we could do better, where our policies were unclear, where our documentation rules were not sufficient. And we really have made very significant changes, both in terms of how someone can or cannot be entered in the database, and then obviously for removal, making it clear, making it tighter. I think that's very important. I think it's actually crucial. We want the database, it has to be accurate, it has to be precise. If we don't have the documentation, that person should not be entered. If the removal criteria are not satisfied, the person needs to be out. And then that's, as I said, that's played out in the data. You've seen the size of the database, shrinking significantly over time.
And in Intro 798, part of that bill is if a member of the NYPD who used the database would be subject to financial penalties, to civil litigation, including punitive damages. Now, that would be another reason why people would not want to become police officers.
Right. So to be clear, I mean, obviously we think that the database should not be eliminated. Full stop. Full stop. We feel very strongly about it for all the reasons that we've said. On top of that, I will say this idea of punitive damages against the police officers. I mean, again, it's completely unnecessary, completely unwarranted. If the database is eliminated, we will follow the law. If we are barred from using it, we will not use it. I think it'd be a terrible mistake. I think will have, really harmful consequences as a public safety matter, and also as a matter in terms of who is flagged as a gang member. Because as I said, without the database, you're going to have the situation where there are no checks, there's no oversight, there's no documentation, it's word of mouth. It's someone saying, well, there's no database, but I heard from somebody, I think this person might be a gang member, maybe someone said something about that, and that's terrible. We don't want that. Whatever concerns you may have about the database, the alternative of no database, no rules, no oversight, no DOI auditing, just word of mouth in the precinct among cops, that is 100 times worse. And I really would urge the critics of the department and the critics of the database really to think about that. In a world in which the database ceases to exist, what does that world look like on a public safety perspective? But also, what does that world look like in terms of cops flagging people as gang members? Because the way it works now, right, we have these rules, we have this oversight, we have this documentation, and if the person's not in the database, someone says, oh, that person's a gang member. No. We have rules. There's oversight here. You can't just throw that around. Right? Executives will not accept that.
Right.
In a world in which we get rid of the database, that all goes out the window.
Right. Getting rid of the database is just insanity. It would cause chaos in this city. And Chief, to speak to your statistics, which I think are really compelling, is that, the amount of people, 1%, when, such a large number of perpetrators of crimes who have been arrested are, underage. So I just want you to add just answer this again. I know you've answered it before, but how many safeguards are in place on the database to make sure only people who need to be listed are there, and what triggers it?
Right, and so we got rid of some of the things that could have gotten someone in before. Now, the only way it can happen is either someone self-admits, either they're saying it, let's say in an interview with a police officer, or via their own social media posts, not someone else's, their own social media posts. They are in a variety of ways admitting to gang membership. That has to be documented. Not enough that some cop just says so. If we're relying on social media, we need the actual screen captures, right? For supervisory oversight and for DOI if they're doing an audit. So anyway, and then that's one path. The other path is if, as part of an ongoing investigation, they've been identified as a gang member, and on top of that, there are two independent individuals, reliable individuals, who have said, yes, this person's in that gang. So those are the only two paths. And it's really important, because I know that there's been some confusion about this. This idea that you could get in the gang database because of just who you associate with or where you live. And I will say, I think this was a critique by DOI. It was a fair critique that under the old system, there was a piece of that existed out there. And we have totally eliminated that. And that's really important. And then if you meet those criteria, we have the documentation, there's multiple levers of supervisory oversight. Only certain teams within detective or intelligence bureaus can nominate someone for the database. Their immediate supervisor has to sign off. It then goes to a separate supervisor in real-time crime. And that supervisor, I will note, right, they're not involved in this investigation. Right? They're separate. They're not invested in this. Their job is to apply these rules. And I will tell you, we have lots of situations in which a detective says, hey, this person should be in the database, and it gets rejected. And real-time crime says, no, we're not going to do it. Sometimes the detective's frustration, right? The detective says, hold on, I'm really sure this person's in the gang. And we say, no, we have these rules, we have documentation requirements, no documentation, not going in. So we really have tightened that up tremendously. And then on the back end with the removals, again, I think DOI had a fair critique before about sort of the removal criteria being too kind of amorphous or unclear. We have tightened that up tremendously, right? And I listed the criteria before. There's no wiggle room in that, right? If those criteria, if one of them is not satisfied, the person is out, period.
Just if I can add some data to this. So in 2023, 201 individuals were inputted into the criminal group database. 1,633 were removed.
Wow.
Last year, 481 were put into the database, 1,559 were removed.
Thank you for that data. And I'll just conclude with saying the reduction in crime that you are testifying to here today is in spite of actions that were taken by this body, like the All Stops Act and trying to get rid of the gang database and impeding DNA collection. So I really want to commend you on the work that you do to get violent offenders off our streets and keep our public safe. Thank you.
I do want to apologize to the borough of Staten Island, because they also had the lowest shootings in the Comstat era. So it was Brooklyn and Staten Island. Can't forget about Staten Island. Sorry about that.
Thank you, Chair, and I'd like to be put in for a second round.
Sure, thank you as well. Just for clarification, can you give me those numbers again? The input and then the removed?
Yes. So in 2023, it was 201 were added, 201 individuals were added into the criminal group database, and 1,633 were removed. And last year, 481 added, 1,559. And it's the same going back to, well, almost the same going back to 2022, more removed than added. Same thing in 2021, more removed than added, and same in 2020.
Thank you. We'll now hear from Councilmember Holden for his questions.
Thank you, Chair, and thank you, Commissioner, again, for an outstanding testimony. As always, you came prepared. Your team is very prepared, and you know we heard about the benefits of the gang database today, but sometimes that just goes in one ear and out the other because it serves a key function for NYPD. For any law enforcement agency, you have to know who you're looking for, what area to start. You just can't say, well, let's look over the 8.5 million people in New York City and let's start from there. So crime prevention, you talked about that. You catalog individuals suspected of gang involvement. That's where you start. Basic police work. They want to take that away from you with this. It's ridiculous. It's totally ridiculous. It's against common sense. You know, the way you identify patterns of violence is police work, drug trafficking, police work, other criminal activity. You have to know where you're looking, who you're looking for. Resource allocation, like you mentioned, is driven by policing. It relies on tools like the gang, one tool like the gang database. It's not the only tool. It's good detective work. It's asking questions. It's talking about individuals and understanding where to deploy officers. Because you know, if there's a gang shooting, they're going to retaliate, most likely. So you know where to look. Also in the case resolution, the database aids in solving crimes by linking suspects to gang networks. Take that away from NYPD, you're going to have more gun violence and just violence.
And if I may, just an additional point that hasn't really come up yet, but I think is actually really important, is, you know, one of the many phenomena with gang violence is we have some long-standing gangs, but unfortunately we have new emerging gangs. Tren de Aragua being the most prominent example. Here you have, it's a new gang, incredibly violent, incredibly dangerous. And it's new. And it's precisely in those situations where you have a new emerging threat to public safety, you need intelligence. We desperately need intelligence.
And you have a database on those gang members too.
Right. Well,
so we should take that away and not know who they are. I mean, that's what this bill does.
And that's the thing. I mean, Chief LePetri was saying before that it's a piece. Of course, intelligence is only going to be a piece. It's intelligence and then using that intelligence soundly, carefully, precisely, with the expertise that our chiefs have, the executives have, right? So sure, it's not intelligence alone, but intelligence is a crucial part. And the notion that you would simply like remove the intelligence piece, that makes no sense.
Yeah, and if I could just piggyback that Tren de Aragua portion, we spoke, it's really hard to get into that database. We spoke to that, you know, even in the world of gang members, you know, there's very few individuals that go into, not every gang member is in the database. It's truly the worst of the worst.
Right.
But we spoke about arrest history and how many arrests individuals had. Tren de Aragua, right? If there's ever a time we need this, it's now. Now, I want to speak to, we spoke to the 99% of individuals in the database that have somewhat a very robust arrest history, but then there's that 1%, right? There's that 1% which really has no arrest history, and that's our Tren de Aragua individuals that we need to really monitor now more than ever. Now, I want to paint a picture for you. In the month of January, we had three Tren de Aragua gang takedowns. Now, embedded in those gang takedowns, we had several members that had zero criminal history. You know what we took from those gang takedowns? In excess of 70 firearms, several ghost guns, an AR-15 ghost gun, a switch, which essentially makes a 9mm fully automatic. These are the individuals that need to be tracked more than ever. And if we give that up, we cannot track it. I also want to just speak very, very briefly to how time-sensitive this is, right, for the rapid deployment. I'm just going to give you two quick scenarios. The first is just, and it's because of social media. Individuals go, they post themselves on the opposition's block, right? We have to respond to that immediately because the world is watching. We have individuals out there, especially in the world of drills, that have in excess of 40 million followers. And what do? They're actually enticing and encouraging violence. So now you need that quick response, right? And you're going to get it almost immediately. You need that response immediately. And if we don't have this gang database, we just painted a picture on how challenging, how difficult it is just to get into the database. Imagine starting from scratch each and every time we're faced with those scenarios. But I hear the...
Yes,
and I just want to
but still with a limited, and I know detectives in my precinct, it's about half the size of what it used to be. And then we have more cases now. But talking about Tren de Aragua, they were trained to shoot at police officers in their home countries, right? And you have to know all this stuff when you go after these guys. But more often than not, let's just talk about general gang activity. When they shoot, they don't go up to the person usually. They're shooting from distance many times. And they're hitting innocent bystanders. We had children that were killed, shot, mothers with babies that were shot. This is what you are going to see happen more often if you take away the gang database. It's a key police tool. Thank you so much.
Couldn't agree with you more, and I'll give you 3 examples. In 6 days in Southeast Queens, on September 12th, a 75-year-old man was shot in the jaw while pushing a shopping cart. On January 16th, a 66-year-old man was killed while driving on Baisley Boulevard. On 9/17, a 74-year-old was shot on Farmers Boulevard. All 3 innocent, unintended victims, all 3 crew-motivated shootings. One of the individuals arrested in the criminal group database.
And again, we have to hear about the victims of these gangs, which you rarely see here or on the steps of City Hall screaming and yelling. What you need to do is get the victims and have them come to these hearings and testify the impact of their families losing a loved one. And we're not hearing that part of it. Thank you.
Thank you. I'd like to turn the questioning over to Councilmember Palladino.
Good morning, and thank you so very much for being here. I'm kind of doubling down on my colleagues, but first I want to say kudos to each and every one of you. Kudos to the fact and figures that you delivered here for us today. I want to say the truth is a very tough pill for people to swallow. And that's what you're giving us all today. You're giving us precise information that everybody needs to digest and understand the reality of what is going on in New York City today. What you did today for me was educate me on your actual numbers and how you have purged the gang database already. Asking somebody or having somebody in the gang database for a lousy 3 years, come on. Give me a break, okay? Everything has been followed to the letter. This is not a racially motivated anything. These are facts that we have to deal with, and you guys are left to do the dirty work. The fact that we have got cops retiring and leaving service before their time is due is because of the way they're treated here in New York City, and sadly by this council. This has become a war on you once again. You know, people's memories are short, real short, because when we got our illegal immigrants in here, and they come here in large numbers and as gang members, TDA, as they shortened their acronym to, the fact that they use social media in the way that they do, the fact that you are left with the burden to carry and try to prosecute is almost impossible. But let me say this. I've watched here today your words get jumbled up, once again get prosecuted for what you're saying, or they rearrange what you're saying. Let's be very clear here. The gang database is an essential tool for law enforcement in combating gang-related violence, which constitutes a significant portion of the criminal activity in many communities. By maintaining a comprehensive and up-to-date database, authorities can effectively identify known gang members, track their associations, and monitor their movements. This intelligence is a crucial tool for understanding the structure of dangerous gang networks, predicting potential conflicts, and preventing violent crimes before they occur. If such a database were to be eliminated, law enforcement would lose crucial historical data and intelligence, forcing them to start from scratch in mapping out gang activity. This loss of institutional knowledge would severely hinder investigations, disrupt ongoing efforts to dismantle criminal organizations, and to allow gangs to operate anonymously. Maintaining a gang database ensures continuity in the intelligence gathering, enhances public safety, and provides officers with the necessary tools to combat organized crime effectively. Illegal migrants committing some of the most violent crimes in New York City are part of our gangs, and our removing the gang database seems like a tactic to help protect the illegal criminal element we have now invading our city. I made this statement because you have been interrupted countless times. This is for the record, for everybody to understand how crucial and how ludicrous the idea is of this passing in council. Absolutely ludicrous. It just hits you with another blow. Another young guy, young girl will no longer want to become a police officer, or they will be trained here with New York City skills, the best in the world, and take it elsewhere to make a living. So thank you very, very much. I don't have a question for you. You cleared it up beautifully. Thank you.
Thank you. We'll now pass it to Councilmember Vernikov.
Thank you very much. Can you hear me? Is this working? Thank you very much, Chair. First question for Mr. Gerber. Mr. Gerber, is DNA collection for minors prior to arrest constitutional?
Right, so it certainly can be. Obviously, it can be done consistent with the Constitution. There are, juveniles can give consent, and obviously, a court will look at that, of course, and analyze whether the consent was in fact given. Did they have the ability to do it? Did they understand what was happening? There are a number of factors that will go into that, always, including the person's age, which is a relevant consideration.
But generally, we've been doing this for years.
Right, and I just want to be clear that while it's a multi-factor analysis, the answer is yes. Juveniles certainly can give consent. And juveniles certainly can give abandonment samples. That does happen. It's not particular in New York. That's across the country as a matter of constitutional law and New York law. There is nothing prohibited in that regard. No.
Thank you. And Chief, My colleague mentioned earlier that DNA is not the only piece of evidence that could help you secure a conviction. But can you talk a little bit about how crucial DNA is to securing a conviction?
Sure. I mean, in a lot of cases, you know, DNA helps substantially in securing a conviction. You know, a lot of our gun arrests are you know, a DNA sample will either be requested by an ADA or obviously an abandonment sample to put a, you know, a profile on that DNA and ultimately see, you know, the percentage of that person's DNA on the firearm. Obviously, in other cases, sex offenses, burglaries, violent crimes, and you know, obviously, it definitely helps us securing a conviction.
So you would say it's crucial?
Yes.
Thank you. And on Intro 125, based on your experience, how willing do you think parents or attorneys would be to cooperate with DNA collection of their children or their clients?
I can't speak to data behind it, but you know, that's why we have strict guidelines in place to have a parent or guardian present when a juvenile gets arrested.
But just in your opinion, based on your experience, do you think they'd be willing? Do you think parents would be willing to give consent for their children to give DNA?
I can't speculate on that. I'm sorry.
Okay. And can you talk a little bit about how these bills will impact your ability to combat gun violence in the city?
The criminal group database is crucial in gang violence in New York City. And, you know, just to remind everybody, 65%, approximately 65% of all our shootings have a gang or crew nexus, 65%. And that's the low number. I feel, you know, doing this for a long time, I feel it's closer to 75 to 80%, but documented, it's approximately 65%. And we have to move speed, deployment, precision, both on the operational side and the investigative side has to be very, very fast. We're not talking about precinct-to-precinct feuds anymore. That's gone. We're talking borough to borough. We're talking about the southern tip of Queens to the northern part of Brooklyn, over to Brooklyn South. When you talk about the Bronx, you gotta talk about Manhattan North. We have to move through, we gotta move to 3 bridges. Whether their mode of operation could be a city bike, their mode of operation could be motor vehicles, whatever it might be, could be transit. It's a multi-bureau approach, and the intelligence has to be analyzed, and a part of that is the criminal group database.
Thank you.
You're welcome.
Will these 2 bills, if passed, will they hurt the ability of the federal government to prosecute criminal gangs under RICO?
It could. I don't want to give, you know, a definite answer to that, but I will tell you that one program that will cease because of not having a criminal group database, and that's the ceasefire program. We talk about connecting gang members to social services. Well, you have to be in the criminal group database to be part of a ceasefire enforcement action. And the larger part of that is the social services that are being offered to the crew members. So no criminal group database, no ceasefire. Ceasefire enforcement action, Lafayette Gardens, Bedford-Stuyvesant, started in December, 8 shooting incidents. Since, 0. Again, part of it is the criminal group database.
Thank you, and just one last question. Would Intro 798, and I know we discussed this earlier, would Intro 798 also eliminate every illegal migrant on the gang database? For instance, like the Trandela-Ragua, I don't know if I'm pronouncing it right. It's a Venezuelan prison gang turned transnational criminal organization.
If Intro 798 becomes law, the database will be completely shut down. We will not be able to use it in any way for any purpose in connection with any member of the database, period.
So yes.
Everybody in the database. There are no exceptions in the bill.
And no more data either.
Thank you very much, and thank you for your service.
Thank you. We'll now hear from Councilmember Joseph for her questions.
Thank you, Chair. Good morning. How many individuals under 21 are included in the gang database?
Under 21, so it's 162, which is 1% under 17. So 18 to 24 is 17%. That's how I have it.
How many times has the department notified a parent of their child's inclusion into the gang database? And since you implemented the recommendations from DOI?
Right. So as one of the recommendations that we accepted was this idea of notifying parents when a juvenile is entered into the database. We agreed to do that with a carve out if it's going to compromise an ongoing investigation. There are certain circumstances in which it would be wildly inappropriate to do that. Some situations where it would be fine. In full candor, we have not yet done a good job of implementing that. And I'll tell you why. I think we thought about it on reflection the wrong way. We sort of had a system in place where we said we're going to have the YCOs make the notifications. And there was good reasoning behind that. I think that was an error because you have the detectives working on investigations and you have the YCOs who are supposed to make notifications, but no one really owns it, if that makes sense, or no one has owned it. And that's been a problem. So on the one hand, I want to be clear, we are committed to what we said we would do, which is to have a system in place where appropriate to make these notifications. We actually, sort of as we speak, are revamping the system because it has not been working well. And I think the plan going forward is to actually have the Detective Bureau own this piece as well. That way there's no question of who's responsible for this. And quite frankly, if you're making notification to parents are going to have questions.
Absolutely.
Right. And we need people making notifications who actually can answer the questions. I think one of the many problems in what we come up with, which again, we're totally revamping, was the idea of having YCOs make notifications when, of course, the YCOs know nothing about the investigation of the case. So I totally understand the question. We are working on that as we speak. We are revamping that whole process.
And have you ever gotten a parent that objected to their child being placed in the gang database?
So one of the many problems that we don't have good data on this because no one had ownership, no one was tracking this.
So who's going to own it now? Now that we're here.
It's going to be the Detective Bureau. The Detective Bureau is going to own this. And they're going to have to be, again, I want to be clear. If we have an active investigation in some circumstances we can't go tell the parents. We can't do it always. I want to be very clear about that. I think we were clear with that when we responded to DOI. But if it's not going to compromise an investigation, we do want the parents notified for all the reasons.
Because I'm very concerned as a parent.
Yeah, no, 100%.
I'm a parent, and I'm very concerned with that.
100%. And so what you're going to see going forward is a better system with the Detective Bureau owning this, and frankly, we'll have data on what we're doing and tracking that. But that's something we're working on as we
Right. In our business, data drives everything we do, right? Data drives the policy. Data keeps us informed. So
yes.
What's your next step is to capture data? When is that going to happen?
So we're going to put out a new policy, right? Because again, the policy at this point has not been working well. We're fixing that, and we're going to put out a new policy in the Detective Bureau in terms of the detectives owning this. And then, look, in candor, we still have to figure this part out. The data piece we have to be capturing accurately when we're making notifications and when we're not. And if we're not, we need to be documenting why. And again, I think there is.
But how long has this database been in place that this work hasn't happened before? That it's happening. I kind of feel like we're building this plane as we're flying it.
No, I disagree with that. I think what happened was in 2023, DOI issued its report, made its recommendations. Late 2023, we adopted the majority of them. Put in place new policies, new procedures, new documentation requirements. I think in most respects, that has gone very well, and you see that in the data. You've seen the additions to the database drop pretty dramatically. You've seen the removals go up pretty dramatically. As you say, so I think good data reflecting some pretty significant policy changes and some pretty significant practical changes.
For the record, again, could you remind me how many people were taken off that database?
Yeah, so in 2024, 1,559 were removed. In 2023, 1,633 were removed.
So what percentage does that represent that was on the database?
So well, I'm not gonna, I don't want to do the math on the fly. Right now in the database, we have a little over 13,000.
So 10%.
Yeah, so we're talking about roughly 3,000 out over the last 2 years, down to 13, down to 13,000. So let's say that's a 3,000 reduction off of 16,000. We're talking what, 20?
Would you be able to get that data to the council? Would you be able to share that data with the council?
100%.
We would love to see what that looks like.
Yes, we'll do.
I have another question for you. Does the NYPD have any intervention programs to support youth that had previously experienced gun violence? You spoke about that earlier. In your community, ceasefires. Are young people also part of this conversation as you're putting out these programs?
Absolutely. And what we do during the summer with that 1,000 young people that we hire in the police department, do DYCD, that partnership, we do a number of different focus groups to find out what kind of programming that they look for. What we did with the aviation program, when we just started on the polo grounds, the young people wanted that type of programming, and working with Commissioner Keith Howard and his team at DYCD, we was able to get that off the ground.
So do you find that these programming, does it deter young people from going back to the life of crime you're trying to save them from?
Absolutely, and I want to shine a light on some of the success stories with that, because a lot of, when you talk about school safety agents, which the Community Affairs Bureau oversees.
And what role does school safety agent play in this? I'd like to know.
School safety is a big component of that. So the Community Affairs Bureau, we oversee school safety division. The school safety agents, no one knows our kids better than the school safety agents. And my community affairs officers in all 78 precincts, they work very closely with school safety, and that partnership has been phenomenal as far as finding different programming and building those relationships. When we talk about trust, we want our school safety agents, our police officers to have those relationships with those young people. And the best way to do that is sometimes working with Keith Howard and DYCD, but also creating some of the programs, because the men and women of this department has a lot of expertise, and that summer youth employment opportunity that we do with DYCD is so important, because young people are placed in all of the different areas of the police department, from our aviation unit, harbor, electricians. We have people on this job employed in the police department that has a number of expertise that we're able to put those young people with. So it's not all about joining the police department. We would love that for them to take the test and come on the job, but it's about young people staying out of trouble and learning more about the human side of what we do every day.
You gotta trust the messenger. So what role does that play any role in discipline? Do you follow that? Do you track that, the interaction with you guys in school discipline and school safety and all of that?
And some of our programs we do. So some of our programs, it's a constant, the same officers that are working with the same students. With our neighborhood coordination program, we have a location up in Harlem, Brooklyn, and Far Rockaway. Those officers are in the same schools, in those programs, mentoring with the DOE. That's a close partnership, so the officers do follow up if the young people are actually doing better or having issues in school.
Do you capture that data to see what's working and what's not working?
I can check on that for you and see, but a lot of those programs are built around that data and that information, so I can get back to you on that.
Thank you. Thank you, Chair.
Thank you.
Thank you. We're going to start second round of questioning. I'm going to relinquish my first term to the public advocate, and then I'll follow up after the public advocate.
Thank you, Mr. Chair. One, I did want to just give credit when I was doing the work on SYAP. NYPD was consistently one of the highest agencies that hired some of these employees. I'm not sure if it's still the same, but I just wanted to give some credit there. Just really quickly, for folks who are in the audience, how many people either have a family member or a friend who's affected by gun violence or violent crime? Just raise your hand. And of those, how many people want us to get rid of the database? I want to say that because very often victims are brought up in a way that's meant to harm the communities the victims came from. And quite frankly, if you speak to the victims, all they really want is this to be prevented. They want it to stop. They also don't want the over-policing that often comes with it. And so if we want to talk about victims, I think we should speak to victims and bring up what they're really struggling with. I also am always interested in the representatives of communities that don't deal with this violence and how loudly they speak about or against the communities and the organizations and the leaders that actually live with this violence daily, go to the funerals and console the families, who, for whatever reason, are thought to be, I don't know if it's genetically or socially designed to not have understanding of what's going on in the community and what they need to stop it, things that they've been asking for a very, very long time that have not happened, but continually get law enforcement and arrests, and generationally, the violence is still occurring. I believe you said, sir, you thought that about 75% of the shootings were gang-related. Is that correct?
65.
You said within...
It's my feeling, yes, that it's actually higher, yes.
And that's because of your history working on it? For how long?
Yeah.
For about how long?
31 years.
And so has the gang database changed that percentage?
I don't understand.
Has the gang database changed the percentage of the shootings that are occurring in gangs and street crews?
It fluctuates.
Okay, but you just said that because of your history, you believe 75% of it was it. And over that time period, the gang database has existed, so it hasn't really done what we wanted to do.
No, I could not, I'm sorry, I cannot agree, I cannot disagree with you more about the use of the criminal.
Wait, stop, I don't have that much time. I was going by what you said. I just repeated what you said and the percentage of the shootings and where they come from, that's all. But my other question.
Can I just say something? You know,
but
we're talking a
you
lot
can answer
today
this in my
about
next
victims.
question.
Let's remember the victims.
Sure, yes, I am remembering the victims. More than you.
No, that's not.
I have been to more funerals than you, I guarantee. And they look like me, and their mothers look like mine.
Okay.
Do not believe that you care about this violence more than I do, or the people who are here, or the people who are there. Don't do that. Do not do that.
First of all, don't.
No, stop.
No,
do not do that.
No, call this to
order. Do not do that.
Don't talk to me like that.
No, you will not do that.
Don't stand up.
You don't know about this violence the way these people do. You just don't.
First of all.
You just don't. Don't do that.
Do not talk to me.
But I will.
No, you
don't talk to me like that.
And I'll talk to you like that.
No, this is the problem you have with the community.
No, I don't have
I'm glad it's being shown right now.
We're gonna
exactly the community.
This is a hearing.
We're gonna just maintain.
I'm
not gonna be talking.
You spoke to me that way first.
No, I did not.
You absolutely did.
No, I did not.
Yes, you did.
Let's just level set. Let's level set and make sure that we provide and allow decorum in chambers.
We are dealing with communities that have generational traumas of violence, that have been asking for certain things, and all they keep getting is arrests and more arrests. I am very clear that there are people behind 911 calls that respond to things that are also dealing with trauma and are human beings that want to go home. And what I keep trying to say is let's stop putting everybody in these situations when it's not addressing the causes of what we're asking for. My next question, what we're trying to deal with. My next question is, I believe you said that if the database is taken down, the good work of the collaborative policing around ceasefire would have to stop. Is that correct?
As it is presently built, yes.
Okay. I believe Deputy Commissioner Gerber testified that we don't share information from that database. So how would it stop if the information is not shared?
We do not share.
So how would that impact the collaborative policing of ceasefire?
It's who the department, the NYPD, will actually put into a ceasefire action.
Yes,
but wait.
I
didn't finish.
So, but no, because we said they don't share, but they are still able to put them into those programs. So my question before was, why are we not able to do that in many different ways? You don't have to necessarily share it in the way you're talking about to be able to get the resources to the individuals. And just so I'm clear, the DA and Project Restore actually shared information about who they thought would be the most violent folks, and they shared them into programs that were not led by law enforcement and had a precipitous drop in gun violence.
So just so we're clear, so there's no confusion, right? So for reasons that I think think everyone here appreciates, we do not share, like with other city agencies, who is or is not in the gang database, the criminal group database, and there are good reasons for that. When it comes to ceasefire, I think that's what Chief LePatry was referring to. A huge part of ceasefire is figuring out and knowing who is in particular crews, right? Ceasefire is done on a crew or gang basis, bringing in a particular group at the same time. And how do we know who is in a particular crew in a gang? We have intelligence in our criminal group database that is a starting point, not the end point, but a starting point for that. In a world, so it is separate from sharing with outside agencies. There really are two different things. And I think the larger point here is that in a world in which we are required by law to eliminate the database, and we are not, and if the law also says, as the proposed bill does, that we can't have any sort of substitute, what that is saying is that the department cannot, in a centralized way, track gang or crew membership. That creates a host of challenges. And one of them, as Chief LePatry was referring to, was in something like a ceasefire program, when we're saying, okay, who is in this crew or in this gang, in a world in which we have been barred by law from tracking that, it becomes much more challenging.
So officers didn't know who was in these crews or gangs before the database?
So I agree with you. So I want to be very clear. I agree that cops who are local in a community, right, who work in that community every day, are going to have all sorts of ideas about who's in a gang or crew. No question about that. But two important points. One, as Chief LePatry was saying, some of what we see in gang and crew violence cuts across precincts and cuts across boroughs. And frankly, a detective in the Bronx may know in a certain area, he may know the crew very well. He may not know the crews in Brooklyn well at all. And they say you have cross-cutting gang rivalry, shootings and the like. That's a huge issue. And then second, and I said this before, but I really do want to come back to this. I think this is really, really important. Whatever limitations you may see in the database or flaws you see, at least there are rules. It can be audited. There's oversight by DOI, oversight by the city council. There's data that can be pulled. There are rules in place. In a world in which that's eliminated and there can be no substitute, what's going to happen is, the local cop, in good faith, I'm not saying bad, but in good faith, saying like, well, okay, who's in this crew? Well, there's no database, can't check that. There's no centralized system, can't check that. All right, but I still want to try to do my job effectively. Okay, well, I think I remember somebody said last year that this guy was in this crew. And I think that's a real concern.
I understand. The only thing, and I do want to say that sometimes the context in which I hear the responses of these things is that these communities, what they need mostly more of is punishment. And the reason that's frustrating, like when growing up, I heard about crackheads that were arrested and we have to lock them up. Now we talk about substance use disorder. And just that difference in naming, how we address communities, are different depending who the community we think of. When I think of organized crimes, even in different communities, I don't hear them being solved by abuses of stop, question, and frisk. I hear good police work. When I hear about mass shootings, I hear about people who are otherwise all-American children. Those things are not said about the communities that I've represented and need the most assistance. And when we don't have that view, what we push forward are things that we are saying cause more harm than they're actually fixing. And that's a discussion that I think is important because we all, I hope you believe me, Chief, want this violence to stop. We really, really do. And the things that we're pushing for are not to coddle criminals. They're because what we have done in the past have not stopped these victims from coming more and more. And so I believe that there's a law enforcement component that's very important here, but we have to use it wisely because it does not fix the trust that is going on. And even more importantly, it's not even addressing the violence the way that we said. Even some of the examples that were given of shootings that occurred while this database is existing. I know that community groups that are here also know who these troop crews are and who these members are, and collectively I just think there's something better that we can do, even with your resources, to try to address this that doesn't have concurrent harms that occur. The only thing I'll end with is I think someone mentioned the cops that are leaving, and it is definitely a problem. But from my conversations, a lot of them are leaving because of overtime being checked, not because of some of the other things that were going on. And all I've always said about overtime is if it's so baked in, I don't know why we can't share it with other organizations like the Department of Mental Health and other agencies that can assist with what it is we're trying to figure out. So I hope that you will understand what I'm saying. You will understand the passion, because unlike some of the folks, I know people who have been dealing with this and continue to deal with this, and I've lost count of the funerals and the consolations. It's really hard because these are really impacted people, and you talk to the victims about what they want, and they get sandwiched between violence in the street and over policing that doesn't help them with the violence in the street. And that's all that we're trying to fix. And I don't think the database is doing that. Thank you.
Thank you. I'd like to acknowledge that we've been joined by Council Member Williams. I want to ask a question. Maybe an interesting question. Given the current political climate, I think it's worth asking if ICE or another federal immigration authority requested information from the criminal group database, how would the NYPD handle that? Or, you know, like, would they try any other legal processes to get this information?
Sure. So if you're talking about a request for information from the database in connection with anything related to civil immigration enforcement, the answer is no. We can't do that. Period. Full stop. We just can't under city law. Obviously, you know, in connection with criminal investigations, if we're working with our federal partners, say we're working with the FBI Safe Streets Task Force on a gang or crew case, we're going to share information with them. I think it's actually not so much like who's in the database, but like the underlying information, right? If we're doing a joint investigation with the FBI, a criminal case on some violent crew, they're looking at a crew in connection with a murder, shootings, robberies. The whole point, as part of, let's say, a task force, is in the criminal investigation, there'll be a sharing of information across the board. The expectation is they're going to share with us, and we're going to share with them. That's what it means to do a criminal case as part of a task force and jointly. But in terms of civil immigration enforcement, no, absolutely not. The police commissioner has been very, very clear about this, right? The department is going to follow the law, full stop. We are not allowed to assist in connection with civil immigration enforcement, and we're not going to do that, and that includes anything related to the criminal group database.
Does ICE investigations into illegal border crossings count?
I'm not sure what you mean by that. Again, anything related that's civil in nature when it comes to immigration stuff, we obviously can't be involved in. When you say illegal border crossings, if you mean criminal investigations of border crossings in, let's say, for example, in Texas, we have nothing to do with that. Frankly, I'm not sure I totally understand the question. Again, as part of task forces here in New York City, we are involved in a multitude of criminal investigations with federal partners, and in connection with those investigations, we share information. Anything civil in nature, civil immigration enforcement, the answer is absolutely not.
And just to follow up, how does the NYPD define criminal group for the purposes of database inclusion? And just for clarity as well, what criteria distinguish involvement as an alleged criminal group as compared to other forms of social associations or friendships?
You mean like how do we say something is a criminal group for purposes of the database?
Yes.
Okay, so I guess the best way for me to explain it is these are street-level crews. So I'll give you an example. In the Bronx, we identified a group of individuals that were not in the database. And as our investigations continued, we saw that this small group at the time was involved in organized street violence, meaning built on geography, feuding with another housing development within the southern Bronx. And once we started identifying them and they fit our criteria to be put into the criminal group database, they then were slowly entered into it. Again, it starts with a few, and then it could grow, or it could stay at a few.
And I just want to know, we're talking over 500 criminal groups in our database right now, where even as little as a decade ago, it was predominantly blood and crip. Now, super precise, next level precision policing. We need to know why for that rapid deployment that we spoke about.
And you mentioned the criteria. What is the criteria? Meaning, like that differentiation between a social association or a friendship.
Okay.
You know, go ahead.
All right. So, as described before, it's somebody who self-admits being in a crew. Self-admits, and that's then documented when that person self-admits, or their own social media site with the URL has to be documented and the actual post has to be uploaded into the criminal group database, obviously aligning themselves with a specific crew. And then the third way is during the course of a criminal investigation, which could be a shooting, could be a shots fired, could be a robbery pattern, the investigator identifies that person as possibly being in a crew, and then two independent individuals, like we said before, could be school safety, could be a detective in a squad, could be a police officer in a precinct, and that's the third way. And then ultimately, it's two supervisory approvals, one with the original documentation in the criminal group database by a supervisor, then it's sent to very experienced investigators that have a background in crew investigations, and that ultimately has to be signed off by an investigator also. I'm sorry, a supervisor also of an investigative unit.
Are individuals ever added to the database solely based on where they live?
Absolutely not.
No, and I want to be very clear about this. It used to be that there was a way that someone could be added. Basically, there was like a list of various factors, and if you had at least two of those factors were satisfied, then the person could be added. And I think, look, we took a hard look at that, and we were actually not comfortable with that list of factors because, Chair, to your point, some of those factors seem to go to association and residence, and it never would have been like one factor alone, but we got rid of that entire thing. Got rid of that entirely. So if the question is, could someone be added to the database now because of where they live or even who they associate with? The answer to that is today, absolutely not.
Absolutely not, and actually we work backwards. So we look nowhere where that person lives. They fit that criteria. And then when I mean by working backwards, we then look to see where the majority of those individuals. I mean, that's just, again, going back to precision policing, right?
Right, so
we want to know where retaliatory shootings can happen. We want to know where the retaliatory crew frequents, things of that nature.
Right, in terms of the analysis, what Chief LePetri and others are going to look at, I mean, geography does matter, but not when it comes to admitting someone into the database. Absolutely not. I want to be really clear about that. That was something, frankly, that was a consideration back in the day, and we have eliminated that. It's very important. We've gotten rid of that entirely.
Only three ways described by myself and Commissioner Gerber.
What percentage of individuals entered into the database have no criminal record at the time of entry and were never later arrested or convicted of a crime?
So, Mr. Chair, I can answer it this way. 1% of the database have no arrests. I mean, I have other data points. I can tell you that a quarter of the individuals on the database, or almost a quarter, are convicted felons. I can tell you that approximately one third of the database has either previously been on parole or presently on parole. 45% of the criminal group database, 45% of the individuals have been arrested with a firearm. A third have 20 or more arrests, and almost a third have been a shooting perpetrator or suspect.
To what extent is information contained in the criminal database shared with external agencies for the purpose of federal and, I think we asked this one already, yeah. So that being said, what I'm gonna do is pass it for a second round to Councilmember Williams.
Thank you, Chair. I just was reading your testimony, and you talk about the Community Affairs Unit and programs designed to meet young people where they are. Can you talk a little bit more about the programs? I mean, you reference specific programs, but if you can talk at a macro level, the array of programs that the Community Affairs Bureau is engaged in.
Yes, thank you, Councilman, for that question. The Community Affairs Bureau, we oversee a lot of different programs that I spoke about today, but I think some of the ones that you're going to be very familiar with is going to be our Explorers program. Currently in NYPD, all of our 78 precincts, our 9 housing commands, and 12 transit districts, and we have some ran out of schools. We have over 1,400 young people that are in those programs. Also in the Community Affairs Bureau, every summer we do the Summer Youth Employment Program that I talked about earlier, 1,000 young people. And then we have our Summer Youth Police Academy for ages 10 to 15, where we do that program with the Department of Education. That is a program partnered with them that we do. Is run out of schools. It's with our school safety agents, our officers, and those are really the 3 biggest programs that we have. But we have hundreds of programs that we do in collaboration with city agencies, including DYCD.
Okay, I'm happy you clarified, because our chair here noted that none of those programs are technically within NYPD. I think my biggest thing that I want to just say, I guess, and maybe I have another question, is that what I have found is that the Community Affairs Bureau is sort of what we want to see from policing, especially in communities of color. And what I have also experienced is that the Community Affairs Unit has the least amount of money. Tons of times, and I will continue to say this, tons of times community affairs officers are coming to me for water, for snacks, to host different events, and that to me underscores that they don't have the resources needed to actually do the work we want to see them do. So if you're talking about preventative work and why, our young folks even potentially may end up in the gang database, is because there's another need that's not being served. And so if you are gonna essentially tout what the Community Affairs Bureau is doing, I hope that you are adequately funding that bureau to do the work, because I have not seen that. And I know there's targeted precincts that maybe have a little bit more resources and have different programs than other precincts. It's just, this is another issue I have. There's no congruence across the city, and maybe not each community needs the same level of youth development programming, but there's just no consistency. And I think that's the biggest issue that I have, and the fact that they don't have, they have one of the lowest budgets out of all the different units in the NYPD. You guys spend tons of money on other things that I don't think are necessary, but then spend very little amount of money on the very unit that you're essentially saying is here's how we're trying to address this issue proactively.
Yes, and Councilman, I get back to you on the actual funding and the budgeting. That's not my area, but I will say to you, working with community partners, DYCD, the community-based organizations, and also local elected officials, the support that we get to run those youth programs have been very helpful.
I know, but the department and the police foundation, to also demonstrate that you care about the community, you should assess the budgets appropriately. I just had a conversation with one of my community affairs officers the other day, and I'm going to try to see if I can help them, even with a vehicle. They don't even have a vehicle to get around. They're sharing vehicles in the precinct. Another example is Saturday Night Lights that DYCD funds. I've seen police officers literally just chilling on the side. The kids are like doing whatever. So it's like you have these initiatives and programs that are supposed to be proactive, but it just seems like you're trying to like proverbially like check a box and not actually trying to do the necessary proactive work. It's essentially like you rather use the resources, money, and time to upkeep a dang database or other types of like precision policing models, but then the policing models that I actually appreciate. Like, I actually appreciate my community. That's like my favorite unit in the NYPD, except the aviation unit. They're pretty cool too. Yeah. But outside of that, like the community affairs unit is like my favorite unit in the department. And I have seen historically how this department is underfunded.
So, Councilmember, I would love to schedule a meeting with you and we could talk further about your community affairs office's needs. And I would definitely like to continue this conversation about the different resources that we can work together on.
Okay, thank you.
Thank
and
you.
more consistency across the city. Like, there's a dance program one place in the city, and then you have boxing maybe. It's just no consistency within that unit at all.
I would love to sit with you, talk further, and explain the plan and how this all works together.
And then lastly, I feel like even with the Explorers program, you tend to like get the cream of the crop in the community that actually interact with the police department. Like, you're not getting the kid in the sin on a block. That's not who's in the Explorers program. These are like cream of the crop. And so just another thing, like, it is helpful if you're like recruiting diversity of young people, not just cream of the crop, because I love the Explorers as well. They volunteer at all my programs. Every event that I have in the district, I always have the Explorers. And these are like cream of the crop students. These are not, again, the students hanging on the block.
Yeah. So, Councilman, we do have over 1,000 young people citywide. I will definitely like to sit with you and really talk about that program as well and the young people that we have in that program. Thank you.
Thank you. I would actually also like to sit with you as well, because writ large, I think that the same sentiments that are being discussed, I've heard those same things as well, and we desperately need that. So I'd like to also pass it for a second round to Councilmember Ariola.
Thank you so much, Chair. I know the public advocate left, but I just need to speak to something that he said, and I want to clarify that community does not equal criminals. The gang members are who the criminals are, and they are not members of the community. They prey on the community, and that's who you're looking to identify. And I've gone to thousands of community meetings, and it doesn't matter what the makeup, the demographic is of that community meeting. I've never heard one community member say, I want less cops, more guns on the streets, a gang database to be dissolved, I want no more investigations, I don't want people to just run through chaos while our young people are being recruited into gangs and people are being killed. So it's just, it's la-la land thinking that that's what any person in any community would want. And that's what this would give it. And that's just I can't imagine. Commissioner Poster, we've talked a lot about, and I agree with my colleague, Natasha, that the police could use more money, and we're always fighting for more money. But we're part of a body that wants to defund all the time and all the different programs. But there are programs that we overly fund that are community-based organizations that are supposed to be interrupting violence, working with gangs, working with all at-risk youth. Do you find that those groups reach out to you or your divisions at all? Because they're getting a lot of money from this council.
Commissioner, my community affairs officers around the city, again, I have hundreds of them around the city. They work with everybody. I can't speak specific to the work that they do with that organization, but I can get back to you on that.
Well, I can give you a list of those community-based organizations that should be doing all these interventions, and hopefully they are working with you, and if they're not, they should start, and we should be notified because we're giving them the funding, this body is funding, and they should be doing the work that they're being funded to do. Thank you so much.
No problem. Thank you.
Thank you. I'd like to now pass it to Councilmember Stevens.
Hi, guys. I'm back. Did you guys miss me? No, I mean, I think one, I know our colleagues have said that some of this is like being in la-la land. I am in la-la land because I actually do believe that community policing takes two sets of people, and it's not saying that NYPD is not part of the conversation, which is why I'm always open to meeting and talking and thinking about solutions, and that is who I really am. Nobody cares and fights harder for young people than me, and no one in this council could say that, because I'm always on the front line. I've worked in youth development for 20 years. I've worked in this work and did the actual work. I've stopped gang fights. I've actually stopped beef. And so I know some of the answers. And so for me, it's just thinking about how do we work together to get to the solution. I am not your enemy, and I say that all the time. Yes, people in my community ask for more cops because they don't know other solutions. And so for me, I am about how do we come together and think about solutions that benefit everyone and not just some. I am not trying to handcuff you and take your work away, because even in your testimony, you keep saying that this is one part of multiple things that you're doing. And the reality is, I believe the other things that you're doing are actually much more effective. That's all I'm saying.
I want to be crystal clear on this. The criminal group databases intelligence is what we do, and it's about precision deployment and precision investigations. Without that database, it would be hampering both our deployment and our investigations. And the absolute number one crime strategy of the NYPD is field deployment. And if you look at the data,
and we can look at the data and we can talk about that, but I do actually have some questions. But I think that that's where we differ on it, because the reality is when I sat and met with you guys, we talked that this isn't the only thing that you use. And a lot of times, even when you're saying the deployments, they typically happen after a shooting.
But ma'am, it's really not a fair question.
I didn't ask the question, though.
No, but policing is it's never one part of there's never one part of it.
But I didn't ask the question, I made a statement.
There never will be one part of policing at any time.
And I hear you, but what I'm telling you is I believe that you guys could be much more creative, because the way this is set up, it seems like racial profiling. And you're gonna say that's not what you're doing, but the breakdown of it comes off as racial profiling. And so for me, it's a hard stop. But I do wanna ask the actual question. We can't just we're not just gonna use language.
It is.
Because to just say it's precision, that's a problem for me.
It's a fact.
So my question is, how does the NYPD conduct social media reviews? Because I know that was one of the criteria. How are those specific accounts identified and reviewed, and what policies govern this online monitoring?
All right, so we're talking about public-facing accounts. That go up in a number of ways, right? I mean, sometimes it will be detectives who are investigating a particular crew, right? And as part of that investigation, yes, they're going to look at social media posts from individuals who are involved in crew activity. FIOs, field intelligence officers, again, looking at crews or gangs in a particular precinct.
No, but I'm asking, how were they identified, and do you have any policies that's governing how this is monitored, what this is like? I'm asking for
we have very strict rules. We have all sorts of rules in terms of, if we have, for example, and I don't think that's not what you're referring to, like an undercover, that's one thing. But in terms of the ability of, as part of a criminal investigation, to look at public-facing social media posts, that's just part of what it means to conduct an investigation. If you are looking at particular individuals as part of a criminal organization, you're going to take various steps. One of them is going to be to look at what social media posts they may or may not have.
And the URL and the actual post has to be put in the into the criminal group database for it to be activate, for it to stay in there and be okayed by the supervisor.
But I'm asking just around social media, because again, I think we, as that is growing, I have bills on social media around how things need to be monitored and things like that. And I'm talking about even on the parental side and young people. And I'm asking, do you guys have a policy around this and how it should be governed? What does it look like? Or is that's not something you've done? This is okay to say no, because that's something we can work on.
No, I just want to be clear. There are certain areas, for example, undercover activity, or, for example, anything that went into, say, political activity, we got all sorts of rules, handshoe. I'm just saying that when it comes to, if we're not talking about undercover activity, we're not talking about political activity, we're talking about sort of your run-of-the-mill sort of criminal investigation. I'm not sure what rules you're really kind of, what you're envisioning. We would expect detectives, as part of that work, to look at public-facing social media posts.
And if it's not public, then we get a subpoena.
Okay. So there are some rules, but I just have one more question. Can you explain the difference between active and inactive in the database? Is there active and inactive parts of the databases? I know, like, you review it every 3 years, and so are they just taken off? Are they inactive?
Okay, so I think this is what you're getting at. I think so. So when someone is removed from the database, it is inaccessible to anyone, right? In other words, they're not in the database, it won't come up. It's inactive in the sense that there is a record that they were once there. It's important for auditing purposes, right? If DOI, for example, is part of their audit work and their oversight work, we need to have some record of what was removed, right? But I want to be very, very clear, like that, so when someone is taken out of the database, there's a member of service would not be able to get at that information. They've been taken out. And if they were going to be, let's say new evidence came to light and they were going to be added in, the process would start over. It's not like, oh, you just go back to someone who was previously removed and sort of bring that back. It's not like that. You start from scratch. I think that maybe that answers your question. I hope it does.
Not really, but I'll leave it there. But I just also want to have a point of clarity. Councilmember Williams, she was saying that you guys have a lot of resources, and we're not saying we want to give y'all more money. We're saying we need to shift some of the stuff around. And the rock wall is broke, and so we would like to get it fixed. So that's another thing that needs to get fixed with the community affairs. It's only one rock wall for the whole city, and we've already been getting requests for that as well.
Thank you. Seeing no more questions for this panel, I thank you for your testimony.
Thank you.
Thank you.
I now open up the hearing for public testimony. I remind members of the public that this is a government proceeding and that decorum shall be observed at all times. As such, members of the public shall remain silent at all times. The witness table is reserved for people who wish to testify. No video recording or photography is allowed from the witness table. Further, members of the public may not present audio or video recordings as testimony, but they may submit transcripts of such recordings to the Sergeant at Arms for inclusion in the hearing record. If you wish to speak at today's hearing, please fill out an appearance card with the Sergeant at Arms and then wait to be recognized. When recognized, you will have 2 minutes to speak. Again, that's 2 minutes to speak on today's topic, which is Introduction 125 and 798. If you have a written statement or additional written testimony and you wish to submit that for the record, please provide a copy of it to the Sergeant at Arms so that please provide a copy of that testimony to the Sergeant at Arms. You also may email written testimony to testimony@council.nyc.gov within 72 hours at the close of this hearing. Audio and video recordings will not be accepted. For in-person panelists, please come up to the table once your name has been called. I will now like to call our first panel. Craig Lewis, impacted individual. Babe Howell, CUNY law professor, author of Bronx 120. Vic Dempsey, community organizer with Gangs Coalition. Anthony Poseda, Legal Aid Society, and Aaliyah Guillory Nickens, Youth Represent. And once you're settled, you can start in any order you would like. Just make sure that you press the microphone button and that is red.
Can you hear me? All right. I don't more so want to repeat what Mrs. Althea Stevens said, but being a part of a gang isn't the initial crime. I believe when you commit a crime, you should do the time, of course, but being friends of friends of friends that commit crimes should not be the reason why you're in jail. On the gang database, yes, it is a tool that the NYPD uses, but it might be a tool that makes it a lot more easier for you to do your job. So to speak, if I go to take a SAT test and I have a cheat sheet next to me, I might be able to cheat unless I get caught. Now, the gang database it leaves it open for a lot of people that may not be committing crimes to be persecuted. And I am one of those people from the Bronx 120 that I can honestly say I copped out to a crime that I didn't do just so I could come home. I would hate for that to continue to happen to my community because it's the backbreaker. And how will the youth become anybody that could sit in these chairs if they continuously get persecuted for crimes? Guilty by association isn't a crime in the law. It's not in the law book, not the law that I studied when I was in school. And I feel like the gang database ultimately leaves a lot of the youth susceptible to being in prison for just being from a neighborhood or being in a music video, socializing with a music video. I heard someone up here speak on the influence of these rappers, and we can't ignore the fact that that helps them make their case. A significant rapper from a significant neighborhood who may have fans, and yeah, they might be influential, but maybe there's another way to attack this other than just basing it on a tool. So they said they could use other ways to get rid of these problems, or they could use other ways to find the criminals, but they're basing it on the database. And if that's the easy way out, everything easy isn't always good. Thank you.
Thank you.
I'm Babe Howell, professor at CUNY School of Law, and I have studied gang databases for 15 years. Labeling people as gang members based entirely on lawful behavior, wrong. Labeling groups of 3 or more a gang, wrong. Labeling only Black and Latino New Yorkers as gang members, morally wrong. Yet the database is 99% Black and Latino. There are no white supremacists, no mafia, no Proud Boys, almost no white people in the gang database. Worse than wrong, it's dangerous. The dangers cannot be overstated. Gang-labeled individuals are targeted for harassment. They are over-policed, dragged unnecessarily into the criminal system, losing jobs or falling behind in school. They are denied off-ramps and second chances. They are held pre-trial, which can lead to gang membership and, like Craig said, wrongful convictions. The database endangers the communities as well. Gang suppression increases gang membership and cohesion. Over-policing so-called gangs contributes to the very problem it purports to solve. Communities need programming and jobs for youth, not labels. Gang-labeled individuals have been targeted by ICE and are now being transported in chains to Gitmo and other countries. Looking forward, authoritarian leaders have locked up alleged gang members by the tens of thousands in Central America. This terrifyingly is a very real possibility for our citizens in the near future. All these dangers because of a label that can be based on wishing someone a happy birthday or on lawful activities on your social media. We must erase this dangerous database before the day comes when we wish we had. Now is the moment to protect New Yorkers, to protect our rights, civil and human, to associate with friends and to express ourselves. Now is the moment to pass Intro 798. We cannot afford to wait.
Thank you.
Good afternoon. Thank you, Chair. Thank you, sponsor, for bringing this bill to this hearing. My name is Anthony Posada. I'm a supervising attorney in the Legal Aid Society's Community Justice Unit. I have submitted written testimony, and I want to reserve this time to address some of the misstatements and the myths that were made earlier by the previous panel. To begin with, this database does not produce any public safety at all. We know that the city has an actual program, an evidence-based program, the crisis management system that is tasked of looking at gun violence through the lens of public health, with credible messengers, working with people who are part of the community. And instead of approaching Black and Latino youth and throwing them up against the wall or demanding to know where the drugs are in their community, we have community members that are working with them, that are leading them to services and to real connections that can help their lives. That database does not do any of that. It only leads our communities and funnels them to Rikers Island. It exposes them to increased stop and frisk, which is even more dangerous. There have been alleged improvements to the database. What I know and I have seen is helping people who right now have been labeled and have remained on the database even when they hit that level of review and were kept on the database for arrests that were dismissed and sealed, for things that other people right now are not even getting arrested for. They were kept on the database as a result of that. So this statement of improvements or how the database has gotten better is not accurate. And if anything, it shows that the police do not need this database, that they can continue investigating, that nothing will stop them from investigating. So having a list of 99% Black and Latino people of a system that is already compromised is not helping our communities, is not making them any stronger. We need to abolish the database, invest in programs that are already creating meaningful changes in our community by connecting people to services. That's how we really change this. Thank you.
Thank you.
Good afternoon. My name is Aaliyah Guillory-Nickens. I'm the campaign organizer at Youth Represent. I want to start off by saying the gang database has not been proven to help decrease crime or promote public safety, which we understood during NYPD's questioning. What has been proven about this secret database is that it can be harmful and very dangerous for Black and Latinx New Yorkers that already walk around with targets on their backs just for existing. 99% of individuals on this database are Black and or Latino, mostly young New Yorkers. Gangs are not 99% Black and Latino at all, bringing us to the point that this is indeed racial profiling and not a tool in actually deterring crime. It is hypocritical for the NYPD to claim to be concerned about young people's livelihood when they are at the same time taking it away. With this database, young people's culture and their childhood is being criminalized. Being raised in poverty is being criminalized simply because it's not understood. Public safety and its database are two things that are incompatible. Today, I want to focus on how detrimental this is to the youth that we claim to be our future. The basis of this being on this database is merely where you live, who you know, who you socialize with, what you listen to, or even where you get a bacon, egg, and cheese from. None of those things are crimes. This practice heightens the risk of hostile police encounters and wrongful arrests. It further breaks the trust between police and communities, causing a disconnect that makes their jobs way harder for no apparent reason. To address public safety when dealing with our young people, we need to double down on the investments we continue to ask for. The initiatives that the community affairs person from NYPD offered, such as SYP and programs that are usually hosted by the same cops that terrorize community members, are not enough. First and foremost, summer is one season, so saying SYP is gonna help decrease crime is not enough because young people specifically, need to make money all year round, not just in the summertime. Young people need jobs, resume building, interview preparation, financial literacy, and other things all year round, and what we're asking for is that and for more funding for ATI programs, CMS sites, and mentoring programs. We're asking for affordable housing and mental health services. This will lead to less shootings and interrupt the cycles of violence that we see. In conclusion, the basis of this database and who is targeted discredits the morality of what it's claimed to be. It's not police work, it's police not wanting to work. Thank you, City Council Member Althea Stevens, for being a leader in passing Intro 798, forever speaking for the communities and never leaving out our young people. Hopefully we could abolish this database.
Thank you.
Good afternoon. My name is Victor Dempsey, and I'm a community organizer, an advocate, and a concerned New Yorker, urging the full abolition of NYPD's gang database. I stand before you to ask to end a system that disproportionately targets Black and brown youth, criminalizes our communities, and perpetuates a cycle of harm under the guise of public safety. I want to be clear, this database is not preventative, it's reactive. There has been no time since this database has been in existence where NYPD was able to come in and give testimony to preventing any measures of making a safer community. Over 8 years ago, we sat in these same city council chambers and introduced the issues around the gang database when no one knew about it. And since that time, we've seen time and time again where NYPD only responds to advocates' cries for transparency, cries for accountability, and time again, they come in and they give obscure numbers and act like that they're addressing the issues with it. We have not seen those things be addressed. Yes, we know OIG released a report, and they claim that they have, again, accepted their recommendations. Accept their recommendations to abolish a database that's disinherently racist. The NYPD's gang database is a deeply flawed, racially biased tool that lacks transparency, due process, and oversight. Thousands of young people, predominantly black and brown, are added to this list on vague criteria, social associations, or even the way they dress. Again, in the city council chamber, the previous public safety commissioner who sat here before, Donovan Richards, he asked NYPD in the previous one, if I went and got a bacon, egg, and cheese and had on blue jeans and a white shirt on the corner of Far Rockaway, would I be added to the database? Then Chief Demashe said to him right in his face, yes, you would be if you were associated. I don't take lightly to NYPD continuously lying about their advocacy or what they say is a lack of advocacy for black and brown communities. So I do appreciate the council today standing up for those communities that they serve themselves. Intro 798 is a critical step in addressing these injustices, but we must be clear the database should not be reformed. It should be abolished. The NYPD's so-called inactive list is proof of their continued lack of accountability. And I think this is a big thing here today that they won't even themselves admit to having an active versus an inactive list. So the numbers that we were given today, it also could be obscure. And we still have thousands and thousands of New Yorkers being surveilled every single day, because we know, because we are the advocates of New York. Thank you again for your time.
Thank you as well. I have a question. And this is to the panel. What alternative methods would be appropriate for the NYPD to use for tracking criminal associations or organized criminal activity?
I could start. I think the whole, good. I'll start and give a piece of it. You've heard a few of our panelists say, you even heard some of our council members even talk about it, that there are alternatives out here. We have, like myself, being formerly gang involved, being formerly incarcerated, and still being of community. The alternatives is direct services. That's the alternative. It's not criminalization. And we say time and time again the criminalization of our youth, because what's happening a lot of times is they might see a few kids playing basketball on the court, and maybe that got out of control, and maybe a fight it might ensue. But before they've committed a criminal act, they're being criminalized. So when we talk about alternatives, I don't think that it's a catchment to one thing is going to change everything. I think when we have council members like Althea Stevens to say, hey, we speak directly to these youth, and they're actually giving us the information of what they need to succeed in their own communities. This is not a cookie-cutter issue. I think every community, even though we continue to say black and brown, every black and brown community is very unique to their own needs. And I also think I'm a 40-year-old man who's done my own stuff in the streets, but now next to me I have a youth advocate that I can reach out and call and say, hey, Aaliyah, what's going on with that? What do you guys need? And I hear directly from those voices. So again, I can sit here and say, oh, it's alternatives. Oh, it's credible messengers. Oh, it's a lack of gyms. Every community is completely different. But what I do know is when our young kids see law enforcement turn their lights on and run up to them and ask them where they're coming and where they're going from, that has not been the answer. And it actually perpetuates a lack of trust. So while I would love to give you some framework that makes a lot of sense to us today, I think I want to come to you and ask, don't just allow us as seat at the table, allow our youth and their voices to have the seat at the table to tell us what their needs are.
Just to echo that point, I think that it's hard for us to talk about alternatives because the trust is broken and there's a huge gap in between police and communities, and police can't police right because of the fact that the trust is broken. So we can't really get to the alternatives in terms of how are police supposed to figure out who's on a gang, or how are police supposed to figure out how to address the issue of gun violence, because they can't do their jobs because there's no trust, because they're not doing their jobs right. So I believe if we, get to that root of the issue first and restore that relationship and that trust and hold them accountable to the point where communities see that they're being held accountable and they're not just being targeted all the time and beat and brutalized and terrorized, then maybe we can get somewhere where we figure out what each specific community needs and they'll be more open to talking, because right now they're not going to feel comfortable talking because all they do is get disrespected and they get treated like nothing in their communities. So it's not going to be easy for them to want to come and sit at the table and speak about what the alternatives are if they don't feel like there's any trust and if they don't feel like it's going to work.
I would just add to that one of the examples that was given by the previous panel of a supposed program that does feed its information from the database is Ceasefire, right? And I can't tell you how many people I have helped that have told me that they have been intimidated by officers, approached in their neighborhoods by having detectives knocking on their door to tell them if you or any of your friends engage in anything, any crimes, we're going to come at you with all the charges possible under the law. And I have had no community member said that they liked the program or that they actually got services that helped them progress with their lives as a result of that program, right? It was just straight intimidation, and we know that you are part of another group, and therefore we will come for all of you. That's real. That shows up in people's lives, and that makes people change the way they behave in their own neighborhood. So I don't have, the way my other fellow panelists are saying, an actual proposal or method, but I do know this. Without the database, the police can still do what the police do. They can still investigate. It doesn't mean that they stop investigating, right? In fact, we are now experiencing the lowest levels of shootings in the city ever. And that's a collaboration. It's an effort that takes place among very different groups. It's not just the police. But we have started to believe in credible messengers and in groups that are not tied to the police to resolve these problems. And what we're saying by that is that we believe that the communities can also police themselves. And we're starting to give them that resource and benefits to do that, and they are showing results. I would say we need to come back and double down on that.
Did you turn it off? Oh, sorry. As Anthony said, they can investigate. The materials that they're talking about, like social media posts, aren't disappearing either. If you want to know who so-and-so is, might have an argument with, great. Nothing has disappeared. Maintaining a database of 13,000 individuals is not productive. And what they're doing to those individuals is having a situation where they say a third of them have been arrested 20 or more times. They are picking these guys up for littering, for smoking on the, it's harassment. They are talking to them, and guilt by association can lead to the wrong conclusion. They're looking at the social groups they mapped and jumping to conclusions. They use cooperators and let out the people who are the worst offenders. And I've read transcript after transcript of shooters cooperating and walking out while someone for whom there is insufficient evidence is convicted. Simultaneously, the Bronx 120, half of them not even alleged to be in either of the crews. And we're not talking gangs, we're talking crews. 500 of them, they're talking community, neighborhood groups, friendship groups. So how can they investigate? When a crime happens, they should get out there. They should talk to people if they need to. If they think social media of the particular victim would be helpful, check it out. But do not database tens of thousands of kids for their friendship groups. So A, what they should do is investigate, and B, what they should not do is create a huge database that can mislead and end up with wrongful convictions.
The reason I'm here to speak is because I'm one of the, as you can see, directly impacted individual from the Bronx 120. And I could state the facts that 60 people out of the 120 weren't even in the gang. And 9 times out of 10, those people were on that database. I sat there with everyone. I was the only one away at school, a full-time student. I was about to get my master's. To come back to Gun Hill Road and develop a law firm, all of that was stopped. If a database, for me, could do that, I'm sure out of the 30 people that's been getting raided, there's probably 5 that didn't do anything without the money to pay for a lawyer to even get their voice heard. They're not blessed enough to have people like this advocate or even educated enough to articulate themselves to you. They didn't make it that far. My alternative would be for cops to just do their job. Facebook and Instagram, they're not gonna get you down. You might hear about what happened, but do your investigations. For if you did your investigations, I wouldn't have went through what I went through, and I wouldn't be in all these communities advocating against a gang database.
Hi, how are you guys doing? Thank you all for being here. It's very funny that I'm on this side now. I used to sit with these guys. Actually, everyone on this panel except this young lady who's been to a number of my hearings. So shout out to you for being civically engaged. So we've been in this fight for a long time. And I guess for me, Anthony, if you can just talk to me a little bit about being a lawyer and seeing the impact that it has, because it was very clear today that they kept saying, like, we're just storing it, we're using it for preciseness, and no one else sees it. And I mean, I guess everyone on the panel, anyone who has input, but like, they, you know, are trying to build a story that is just being used for precise policing, and that's the only time it's being used. But if you guys can talk about how it's actually impacting, you know, cases or whatever other areas of people's lives, I think that would be really important to kind of help close some of the gaps.
Sure, Councilmember. I can actually give you an anecdote that is part of my written testimony that highlights a lot of these issues. And in fact, it goes to show that being labeled doesn't mean that your information sits in a hard copy file in a detective's desk. No, it's part of a larger electronic system so that thousands of police officers on patrol right now can pull up their cell phones if they stop somebody and input that information, and boom, so now it's suddenly not dormant. Suddenly it's not just information that, oh, it's very hidden, like in some, I don't know, beneath the chamber or something, and I can't see it. No, that's not true at all. This young person who reached out to us for help was a 28-year-old black male who had been approached by officers who gave him a ceasefire letter in a very intimidating fashion, such that he didn't want to go back to that same neighborhood. He stopped going to that neighborhood as a result of those encounters because they were repeated. It wasn't just once. He comes to us and says, please help me find out if I'm in the database because this keeps happening to me. So we submit a FOIA request during the time that the police was denying every single of the hundreds of requests that we were making to find out if people were on it. They denied us all the way until we had to file an Article 78 lawsuit. We did. The case was settled, and the records that we got, so our client's own records of why he was added on the database showed this. He was added when he was a teenager for mentioning and putting an emoji on a social media post, wishing somebody a happy birthday, as a teenager, right? So you would say, well, now he's coming to us as a 28-year-old, why is he still on the database? It's because of all of these arrests that he was having with the police that had nothing to do with gangs or violent crimes at all. Everything that Professor Howe was just now describing, littering, jaywalking, resisting arrest, obstructing governmental administration, yet he was still appearing on the database. Even decades and years when he had no connection with any of those groups, was not involved, he was trying to get his life together and move on. So the label did not just stay somewhere quietly. It wasn't dormant. It wasn't part of a list that the police don't mind to inform their decisions in real time. It is used in real time. It does impact, and in this case, it was leading this young person to all these stop and frisk, and we can't get him off because people are on there indefinitely, even with these alleged reforms.
Yeah, because I mean, today that was pretty much being said, like, no one has access to it, no one sees it. And even when I had conversations, they were saying, like, they've changed the criteria. It's blind now, so, you know, an arresting officer is not doing it. It's someone else. And so they're saying they're trying to do all these different things. But, yeah, absolutely.
Yeah, Councilman, I just also wanted to add, too, you know, earlier we heard some statement as far as speaking to the victims, right? Everyone you see sitting here, all the communities that we work with and out, they're all victims. When we talk about, you know, they mentioned earlier around harms, you know, I know some other colleagues will speak to that a little bit later, but the reason why I bring it up is because, you know, in my former tenure, we used to go to what they had at debriefings after raids that would happen in all the developments throughout the city. And we would get invitations from NYPD themselves. And what would happen is we would go to these debriefings, and the folks who are in attendance are the community members from these developments. And they were supposed to be getting, I guess, a rundown of what raids just happened in their community. You know, and these raids are happening militarized style, the wee hours of the morning, disrupting homes, right? And the folks that were sitting there was asking NYPD questions like, so what happened? And NYPD would encourage them that they've taken the best of the worst of the worst out of their communities. That's not what we saw in those debriefings. In those debriefings, we're looking at the mothers of these young men and women. We're looking at the sisters, the aunts, the grandmothers, like for real, seriously. And when we talk about victims, these are mothers who now are dealing with permanent exclusion letters from NYCHA because their loved one is on their lease who's been caught in a raid and they're part of their lease. We're also looking at grandmothers who are here legally, and now their grandson is being put up for ICE or detention because of presumed guilt. Not presumed innocence, presumed guilt. So I really just want to highlight too, when we talk about the harms, yeah, we can speak to the lawyers and everybody, but the victims are the ones telling us this. The victims are the entire communities. The victims are the aunts or the neighbors who live on the same block, asking their neighbors, well, what can we do to help?
And I'm going to stop here because I know I've been running my mouth and taking a lot of space, but I'm just happy that you brought up the victim services, because that was one of the things that I brought up in the conversation, and they were explicit that that does not happen, although I've had multiple conversations with families who have been denied victim services. Like you said, even in NYCHA now facing eviction because of the aftermath of what this has created. And again, I want to state, being in a gang is not a crime. And so that's the other piece around it. They have not been charged with a crime. It is just a label that is being policed on them.
I want to share one of the most important effects that I've seen in courtrooms of the gang allegation, and the NYPD is word playing. We don't share the database, but we will tell the prosecutor so-and-so is this crew or that crew. So they don't let you log in, but they give the information. It's also available to each one of those 30,000 officers. However, in courtrooms, it has a tremendous effect. Young people are denied youthful offender, ATI programs, the off-ramps that are supposed to be there for kids making the mistakes kids make, that are supposed to give second chances and bring us back to our communities. Not only are they denied those off-ramps, but in the Bronx 120 indictment and other of the RICO charges, they will use predicate acts where you've already, done 2 days community service for selling weed in the neighborhood and say, this shows that they're part of this crew or gang. So they'll use, in one case, a youthful offender diversion. He finished the program, he was congratulated, he went on, committed no new crimes, and yet the 2 admitted robberies that put him in the youthful offender program that got him into court as a teenager were used as predicate acts for RICO. And he then gets punished again when he has already gone through the program, is living an entirely lawful life. So the gang allegation, getting rid of the gang database is step one. We have to get rid of using this gang allegation anywhere, because it deprives you of due process, it deprives you of alternatives that are designed for just this population, kids who are in trouble. They need our help, not our labels and deprivation of all rights.
Man, I'm so happy that this aspect of the conversation is coming out. I have one follow-up question, and this is maybe more of a legal question, because I didn't know that folks could get labeled for life, like the parents and the loved ones and so forth and so on, just because they're, part of this. I'm wondering, what legal recourses do individuals have as a result of them being, I want to say adjacent, right? My son, my friend, whoever. What legal recourses does a person have, if any? Because if they're labeled for life, I can understand part of the conversation that's held here is that in the best of situations, children who are children do things that children do. Once they become adults, they put away all of those childish acts and they start moving as adults do. But when you have a situation that has been created, and then there's an agency like the NYPD, who is supposed to be protecting and serving, used as the response to monitor what has been created by the system, those same children won't be able to be doing what normal children will be doing, right? It's like you're in the margins of life, you're in the struggle, your back is against the wall. And so I'm just wondering, what legal recourses Because we did speak about, folks as young as under the age of 18 being on the database and so forth and so on. I'm more inclined to find the solutions to these things, and a lot of times it's coming from us, right? It's those who've been not just in pain but close to the pain that can now have a seat at the table to really articulate the issues in the most powerful way.
Let me say we need to abolish the gang database. There is no recourse that can make this up to you. As you well know, no one can turn back the time if you've been unfairly treated under this, because of these designations, because of this database, because the NYPD tells someone you're a gang member. There's no true fixing that. So question one, is there a legal recourse? None that can make you whole. Secondly, there's very little recourse anyway. I mean, first, you take a case, you take these big RICO cases or any case where there's a gang allegation, it is really, really hard to win. So unfortunately, cases that if I had them when I was a defender in 1994, I would get probation, youthful offender, whatever. Now it's like, no, that kid's a gang member, and we've arrested him 20 times because he's in our little database. We want him to do a 5-year bid on that same case. And I'm begging for the 1 year. So I was talking to, I had lawyers in my class last week, and I asked them, isn't it hard to win these cases? Aren't they so easy to prosecute and difficult to defend? And one of the lawyers was like, well, if a person's facing life, then 10 years is a win. That shouldn't be, where the gang allegation just shifts the whole inquiry. With conspiracy or RICO charges, you don't even have to commit the crimes yourself, just be part of the enterprise or part of the conspiracy. So the burden of proof shifts, the due process is eliminated. There is no legal recourse, which is why we're asking to abolish the gang database. There's no other route. The idea that people should have notice, then maybe they can find out, wait a minute, my landlord actually was told that I was in this gang database. Like, there's a world in which we're thinking that if people can find out what the information is, and if it was ever shared, they may be able to find out, hey, I didn't get this job with Department of Corrections or with the NYPD even because I was in the database. Hopefully, we'll find out some of the harms that were done. And by the way, while the DOI starts by saying no harms were proven, on page 22 of their report, they say we didn't even look for harms. That would have been too difficult to figure out what the impact on housing, employment, et cetera is. So in any event, recourse is really hard. That's why we have to stop labeling the kids in these ways. It's not useful. And they have said over and over, these are neighborhood groups. These are not gangs.
Anthony?
While there may be some reentry programs in different fields that allow people to, in the case of NYCHA that you might have heard, the permanent exclusion, that there is a field there for people to be able to come back, but it doesn't separate, or we're not yet done with this part of the conversation, which is that policing in this way is part of just a larger culture of treating Black and Latino and communities of color in this fashion, and so the recourse is really abolishing the database.
Only thing I will add is that as advocates as well, by the time we are introduced to a community member who's been impacted by a gang designation, the damage is already done. A lot of times when folks, and as you heard today, even from NYPD themselves, there is no form of transparency. No one's being notified. And even to back up a little bit further, as I keep making mention of previous city council hearings, there was a push for a notice to minors thing. And unfortunately, we had to really advocate against that as well. Why? Because it's more than just minors being impacted, right? Even though today I'm sitting here saying the voices of the youth is really gonna help us figure out that avenue, but the thing is validating the harms already. Validating a database to figure out another way to use it is a harm. This is why we're all gonna continue to say, abolition. The only other thing, and again, this is not even a legal recourse, but even just for community members to find out if they're on the database. I know my colleagues at Legal Aid created a FOIA, not even created, but utilized a FOIA process just for New Yorkers to see if they're even on the database to begin with that NYPD is already secret about. And we've done our due diligence. We've looked at other states who've had similar issues, and we learned from them. But today, there is no recourse, unfortunately. Abolition is truly the only route. And the last thing, oh man, yeah, I'll leave it to the rest of my colleagues who will speak, but I don't see any avenue.
Thank you for your testimony. I'd like to call the next panel, which is the panel for civil liberties and civil rights. I call up to the witness table Yasmin Farhan, Jason Taper, David Moss, Celine Zhu, Kali Young. I'd just like to remind you all that you have 2 minutes to speak on introductions 125 and introduction 798. If you have written testimony, you can submit that written testimony to the Sergeant at Arms at testimony@council.nyc.gov within 72 hours of the close of this hearing. Audio and video recordings will not be accepted. Thank you. And you may begin in any order you like.
How's that? Okay, great. Thank you, Councilmember Salam. I also have a testimony that I want to share, but also I think needed to respond to one thing that was said earlier when we heard from the administration, from the NYPD, which is that the use of joint task forces as this kind of catch-all rationale for NYPD to being able to share information from the database and otherwise collude with ICE is one that we have to scrutinize very carefully, because when we take a closer look, we'll see that a joint task force, that language, is used as an explanation for any time they work with federal immigration enforcement. And in many, many instances where we see, in fact, afterwards, absolutely zero evidence of any federal criminal investigation took place. So I just wanted to note that before continuing. My name is Yasmin Farhang. I'm the Director of Advocacy at the Immigrant Defense Project. We were founded 27 years ago to fight for justice for immigrants targeted by the criminal and immigration legal systems and combat mass deportation. We joined the call from so many people today already to pass Intro 798 and abolish the criminal group database, which is actively harming so many New Yorkers, including so many immigrant New Yorkers. As we have already heard, this secret list is nothing less than racial discrimination and abuse of power for reasons as arbitrary as scars, tattoos, clothing, and social media posts, often innocuous factors that sentence those on the list to perpetual punishment without due process. We need only to listen to those who have already testified today to understand the deep harms that flow from that database. In New York City, we simply cannot talk about these harms without also talking about the way that these same categories have long been used by ICE to profile, surveil, detain, and deport immigrant New Yorkers, using confirmed or suspected gang members, that category, as a justification for harming young people and separating families. And in New York City, any encounter with the NYPD that results in fingerprint sharing is then shared with the FBI and then with ICE, increasing risk of detention and deportation, whether or not that person is ever charged with a crime, and even where a case is dismissed. With ICE raids increasing in volume and aggression in our city daily, including in a number of instances where the NYPD was actively facilitating, it is unconscionable to allow this database to be used as an additional weapon against immigrant communities. Under the reign of Trump, the gang member label is being further exploited, classifying many tagged as gang members as foreign terrorists. At least 8 gangs so far have been classified as foreign terrorist organizations by Trump executive order, not only triggering detention and deportation, but putting immigrants in the unconscionable position of having to prove a negative, that the terrorism bar should not apply to them while any evidence is happily taken as proof, including inclusion in any gang database. And just as we have heard today about the overwhelmingly disproportionate impact to Black New Yorkers of this database, it is also Black immigrants who are disproportionately impacted by detention and deportation. Passing Intro 798 is ultimately about racial justice, and we further employ this council to support it to guardrail against the NYPD's participation in ICE's cruelty. Just as we call for passage of this bill, we also call for passage of the New York City Trust Act, Intro 214, which will protect against the NYPD continuing to unlawfully collude with ICE. Thank you.
Thank you.
If I may go next. My name is Jason Taper of the Surveillance Technology Oversight Project. This is just an excerpt of my further submission for the record, which I will submit soon. The gangs database is a racist, inaccurate reincarnation of stop and frisk. It is racist because, as previously said, of all possible definitions of gangs, including white supremacists, 99% in the database are Black and Latino. It is inaccurate because it is entirely made up of rumors and officers guessing. Even if it is 2 independent officers guessing the same thing, an accusation does not make that accusation true. You can be in a gang, quote unquote, without any suspicion of any crime. Even wishing happy birthday is something the NYPD considers a self-admission, which gives it away that self-admission is basically NYPD ventriloquism. From these rumors, we get this database, and from this database, we get the harmful surveillance we see in our communities. Surveillance itself is traumatizing. When NYPD says things like they did earlier, like they need to be watched, direct quote, it leaves people afraid to walk out of their house and into the gang database. And those are valid fears. As my colleague says, ICE uses gang databases. And under this administration, we've seen violent raids, imprisonment, including on Guantanamo Bay. We've seen US citizens swept up in these violent ICE raids. New York City should not be complicit in a Trump police state or in the inherent harms of surveillance. There is no public safety benefit to this. Portland and Chicago, for example, abolished their gang databases with no increase in the crime rate. When there's no benefit, and when the very existence of this database is harmful, inherently, only abolition will suffice. That is why we are in support of Introduction 798 to abolish the gang database and any successor database like it. Thank you.
Thank you.
Hi. My name is Celine Zhu, and I am a civil rights attorney at the Center for Constitutional Rights. Thank you for the opportunity to testify today regarding Intro 798, which we urge the City Council to pass. The Center for Constitutional Rights and the law firm of Bulldog Vine Hoffman have served for over 12 years as plaintiffs' counsel in Floyd versus the City of New York, a landmark civil rights class action that successfully challenged the New York City Police Department's racially discriminatory and unconstitutional stop, question, and frisk practices and resulted in the current supervision of the NYPD by a court-appointed monitor. The NYPD's gang database is a digitized version of stop and frisk. The two work hand in hand to criminalize being Black and brown in New York. 99% of the people in this database, we've heard again and again, are Black or Latino. The NYPD admitted that the historical threshold to being added to the database is as low as wearing the wrong clothes, listening to the wrong music, or living in the wrong place. You can fill in what wrong means. From these criteria, 13-year-old children have been deemed gang-affiliated and added to the database. Where is the recourse for all the children who were wrongly and arbitrarily criminalized, or their collateral consequences? How does the NYPD give them back their childhoods? Now the NYPD tells us that their improved system gives us a new formula. We've heard that today it takes 2 school safety officers who have decided that that kid is friends with the wrong person, and they were in the wrong place at the wrong time. something children and youth often have very little say, because not every child has good choices. This directly leads to the widespread violations of the rights of Black and brown New Yorkers. For example, entire NYCHA buildings used to be deemed gang locations, and even if this is no longer an explicit criteria to the gang database, we know they still regularly over-police these areas as high crime areas. And this is especially important because the Floyd Federal Monitor found that in 2022, only 77% of stops at NYCHA properties were lawful. This is a systematized, racialized violation and the deprivation of rights of Black and brown people. The existence of the database also directly translates into more dangerous police encounters. Since the database is accessible to any NYPD officer on patrol, it gives officers cover to escalate encounters with only Black and brown New Yorkers who appear in the database, regardless of why they were added. This leads to more dangerous stops and harsher court outcomes. And the Floyd team knows this to be especially true because over the past few years, we have seen an increase in both unconstitutional stops by the NYPD and in the racial disparities of these stops, with Black and Latinx New Yorkers making up almost 90% of reported stops. And the Federal Monitor's most recent report on NYPD discipline shows that they rarely, if ever, are disciplined for unconstitutional stops. In the same way that stop and frisk was deployed in Black and brown communities as a matter of NYPD policy, the gang database targets the same communities by outright criminalizing their culture, their kinship, and their community. This is race-based profiling by the NYPD. We know this is wrong. Why else would places like Chicago and Portland abolish similar databases? Abolishing the database will not impact public safety since racial profiling does not reduce crime, and neither of those cities reported any related rises in crime. The gang database especially hurts Black and brown children by criminalizing the circumstances of their childhoods, particularly those who, through no choice of their own, grow up in public housing or as immigrants. City Council has an opportunity to allow a generation of Black and brown children to grow up with less police, less suspicion, less violence, less surveillance. City Council has the power to ensure the carefree youth they deserve, and which this latest NYPD discriminatory surveillance practice threatens. For those reasons, I urge you to pass Intro 798. Thank you.
Thank you. I'd like to remind the public that we have a time restraint. And if you have written testimony, you can certainly add it to the testimony that will be captured today. Thank you.
Good afternoon, Chair Salam. My name is Kelly Young, and I'm a state policy advocate at the Innocence Project. Thank you for the opportunity to testify in support of Intro 798. As you know all too well, at the Innocence Project, we see firsthand the devastation wrought by wrongful convictions. After fighting for years for their freedom, our clients suffer the impact of their wrongful convictions and incarcerations for the rest of their lives. The repercussions of a wrongful conviction are broader than just a single individual. They ripple out, affecting families, friends, and entire communities. NYPD's gang database serves as a catalyst for wrongful convictions, creating a pipeline that transforms routine law enforcement interactions into life-altering injustices. The use of gang databases flies in the face of the concept of individualized justice. These databases don't track specific criminal acts, but rather create permanent pools of suspects based on highly subjective criteria. Once included, individuals face heightened scrutiny and increased likelihood of arrest regardless of their actual conduct. Despite the utter lack of transparency, we do know that innocent people are swept into these databases and wrongly arrested and convicted because of them. The Bronx 120 case demonstrates how devastating this system can be. Nearly half of the 120 defendants were not alleged to be gang members, yet they were swept into a massive RICO case. Despite two-thirds having no prior felony convictions, 115 defendants pled guilty to felonies, primarily due to the threat of draconian RICO sentences. Approximately 70 individuals became felons not through their own direct criminal acts, but through vicarious liability for the conduct of acquaintances over nearly a decade. Research has shown that mere association with gang allegations dramatically increases the likelihood of conviction, even when evidence is insufficient to meet the standard of proof beyond a reasonable doubt. This creates a perfect storm where individuals are labeled as gang members based on non-criminal criteria, face enhanced charges and sentences, and then encounter juries predisposed to convict based solely on the gang label. The human cost is devastating. The routine misconduct, I'll end by saying, rather than enhance The collateral consequences associated with being just added to the database are insurmountable. The harms community members endure from this designation is far-reaching and most of the time life-altering. While I understand that the DOI released a report stating that they did not find any harms, please let me be clear that their job was to investigate how the database operates, not investigate the harms themselves. Thank you.
Thank you.
Thank you, Chair Salam. My name is David Moss, speaking on behalf of the Legal Defense Fund. We really appreciate this opportunity to testify in favor of Intro 798. Through the criminal group database, the NYPD relies on biased and unreliable information to indiscriminately designate thousands of New Yorkers as members of gangs. This results in racial profiling and civil liberties violations that almost exclusively harm communities of color, with particular risk to young people and to public housing residents. The database's active list, as we've heard, includes over 13,000 New Yorkers, 99% of whom are Black or Latino. And as of the OIG report, fairly recently, approximately 1,600 people on the list were added when they were children. Criteria for adding people has included wearing gang colors, which, according to NYPD training materials, can include black, gold, yellow, red, purple, green, blue, white, brown, khaki, gray, and orange. Every color of the rainbow. People have been added for being in a gang location, and according to the OIG, officers have often designated entire NYCHA developments in their entirety as a gang location when using that criterion to add someone to the database, meaning that a person can be added based in part just by being in or around their own home. People can be added because of their social media activity, whether it's posting on a friend's page, posting a picture of themselves wearing certain colors, standing next to another person that the NYPD suspects as being a gang member, quoting song lyrics, using certain emojis. Many other innocuous behaviors on social media have been used to add people to the gang database. So in short, the NYPD has given itself the unfettered power and authority to add virtually anybody it wants to the database, and it uses that discretion to exclusively target Black and brown people, and particularly to target young people by criminalizing culture and social media habits that are common among Black and brown youth. And I really also want to add, the database does put people in harm's way. It does lead to more intense police encounters, stops, arrests, longer detention. So it certainly does harm people. As folks have mentioned, Chicago, Portland have abolished their gang database. LDF's Thurgood Marshall Institute did a study where we investigated whether or not that had any impact at all on crime rates. And abolishing the database did not impact crime in those cities. Which tells us that the gang database is not a legitimate public safety tool. So I will just end there because I'm over time, but thank you so much for this opportunity.
Thank you as well for your testimony. Thank you.
Thank you.
I'd like to call up the third panel, the public defense. And just remind everyone that this is a government proceeding. Decorum shall be observed at all times. As such, members of the public shall remain silent. The witness table is reserved for the people who wish to testify. No video recording or photography is allowed from the witness table itself. Furthermore, members of the public may not present audio or video recordings as testimony, but may submit transcripts of such recordings to the Sergeant at Arms for inclusion in the hearing. If you wish to speak at today's hearing and have not done so, please fill out an appearance card with the Sergeant at Arms and wait to be recognized. When recognized, you will have 2 minutes to speak on introductions 125 and 798. Once you hear the time's up chime, please begin to conclude your testimony. If you have any written testimony or additional statements that you would like to submit for the record, please provide them to the Sergeant at Arms, and you may also email written testimony to testimony@council.nyc.gov within 72 hours of the close of this hearing. I now call up the third panel, Public Defense, Ashanti Baptiste, Talia Cameron, Michael Gross, and Scott Floeta. And you can go in any order you would like.
Hello. My name is Ashanti Baptiste. I'm a community organizer with the Legal Aid Society Community Justice Unit. My duties are to provide legal services to the crisis management sites and the broader community as well. Along with these services, we facilitate workshops, the gang database being one that's targeting our children. I have spoken directly with adolescents, young adults, and parents while conducting workshops spreading information about the gangs database. And every single individual reacts differently, but all feeling afraid, shocked, and angry at the same time. CJU facilitates gang database presentations across the 5 boroughs, and the greatest thing I enjoy about engaging with the youth is experiencing that most of them aspire to do great things, are very intelligent and warm-hearted, but due to the circumstances of being underserved, society molded them to be complacent, irrational, and very angry. Black youth just want to be heard, and the only way they have been taught by the world we live in is by violence. This country's history is based on violence. Television, news, reality shows, video games, all based on unleashing your frustrations through violence. So when $1 Million record labels sign kids rapping about drilling, what message is being presented and who's being held accountable? Our youth is being held accountable and not the labels. Our teens suffer from PTSD during COVID, which started the trend of wearing ski masks, a product of the pandemic, and now they are demonized for it. We hear stories all the time of teens afraid at night walking home by themselves because police prey on them. And that's exactly what the gang database is executing. It's not a coincidence being on a database takes away your financial aid, raises your bail without priors, or finds yourself being deported. We even discovered officer bureaus can deny families financial assistance for deceased loved ones for being on the gang database. Why go to that extreme? I have been advocating in Brooklyn for 2 decades, and it seems every generation gets more detached from reality. What they hunger for are higher quality educational curriculums in schools that they can relate to, and efficient jobs providing entrepreneurial training. With that said, gangs are not illegal, but media has made gatherings unlawful when young black youth assemble for fun or boredom, and we need to eradicate that way of thinking. For those that hear my words as rhetoric, just know gangs been around since the 1800s in New York City. Black people didn't create gangs, we inherited that life. Societies offer comfort to white kids that commit mass shootings, but black kids fighting to survive are labeled savages. I'm disappointed the police was not required to stay, but I'm not surprised to hear the community speak. One day they will be held accountable. But until then, end mass incarceration, end the gang policing, invest in our communities and our youth, and pass Introduction 798. Thank you.
Thank you.
Good afternoon. My name is Scott Falletta, and I am the interim managing attorney for the Immigration Defense Team at the Neighborhood Defender Service of Harlem. I would like to speak today about the particular dangers of the gang database bill for immigrant New Yorkers. During the previous Trump administration, ICE used the specter of gangs as a means to depict all immigrants as dangerous. Allegations of gang membership were levied indiscriminately against Central American young men to deport them in sweeps. And the validity of the allegations did not matter, only the administration's ability to claim that it was deporting as many individuals, quote unquote, associated with the gang as possible. This time around, the Trump administration is going even further by labeling those who already have the gang association label on them as terrorists, and applying anti-terrorism laws against them. These are laws that have very low burdens of proof and very high penalties. Members of the military, federal agencies such as the DEA and FBI, and even the National Guard of red states are being activated to create a massive deportation force, which the administration is threatening to unleash on sanctuary cities like New York. And with the Trump administration threatening to expand criminal prosecutions for things such as simply failing to register on an annual basis, the department statements earlier today that they were only going to cooperate with ICE in cases where there is a criminal prosecution give me no comfort. When a gang allegation gets into ICE's hands, it alone can trigger deportation. If a person is undocumented, ICE does not have to prove that they have engaged in any criminal activity in order to deport them. And the allegations alone have been used to deny people bond and deny immigration benefits such as asylum and special immigrant juvenile status. The last Trump administration struggled to find enough non-citizens with criminal convictions to support its narrative of depicting immigrants as dangerous, so it instead relied on allegations. The only way to protect young New Yorkers from their information getting into ICE's hands is abolition of the database. Thank you.
Thank you.
Hi, good afternoon. My name is Talia Kamran. I'm a staff attorney with Brooklyn Defender Services Seizure and Surveillance Defense Project. Unlike our colleagues and community members, BDS strongly urges the council to pass Intro 798. As public defenders, we know that oftentimes the NYPD uses the database to justify arrest based on the suspicion of gang affiliation, which undermines genuine evidence-gathering police work and encourages profile-based policing instead. Inclusion also leads to harsher bail determinations, plea negotiations, and sentencing, fueling our city's scourge of racially disproportionate mass incarceration. What's most at stake, though, is that the gang database is a driving force behind racially biased, unconstitutional stop and frisk. Based on what we've seen in our office, DCLM Gerber's claim that the database is not the impetus for stops is absolutely incorrect. Policy does not equal practice and reality, and oversight does not mean compliance. We frequently see that young boys of color are stopped, questioned, and even arrested for minor petty crimes purely to seek information for the database. We see youth arrested for violations like disorderly conduct, and they should simply be issued a desk appearance ticket, but instead they're interrogated for hours about what gang they belong to and who they know. NYPD then has a common practice of seizing their phones in these instances, despite there being no connection between any investigation of such a low-level offense and a cell phone. And it's clear that these minor arrests simply serve as an opportunity to seize data about youth, their friends, and to add their contacts to the database. I'd also like to speak to something else that DCLM Gerber mentioned in his Q&A. He said that the department's policy is to contact parents and allow them into the room when a child is undergoing interrogation. But again, policy and reality are oceans apart for the NYPD. We frequently see that parents are failing to access their kids in precincts and when they're undergoing questioning. And often the police department will claim that they need to unlock a phone to call a parent, and then they'll take that child's phone. We've seen children as young as 11 years old get stopped and frisked based on the gang database. And so we strongly urge the council to pass 798, and we thank you for this hearing.
Thank you all as well. Appreciate it. I'd like to call the last Advocates and Public Defenders group, Alex Vitali, David Pilar de Jesus, Christina Chase, and Lex Colleen. You may begin.
Good morning, good afternoon, Chair Salam, and thank you to you and to the rest of the committee and to your staff for putting this hearing together. My name is David Sifford. I'm a member of the board of the Jim Owls Liberal Democratic Club. The Jim Owls Liberal Democratic Club formed to provide the New York LGBT community with a progressive citywide democratic club. Our mandate is to see to it that the rights of LGBTQIA+ community are protected and advanced. We support Intro 798 to abolish the NYPD criminal group database, also known as the gang database. Nationwide, LGBT individuals are more likely to be arrested and incarcerated than our straight cisgender peers. This begins with youth, where queer youth are over twice as likely to be involved in the juvenile justice system, and adults are twice as likely to be arrested and 3 times as likely to be incarcerated. In New York specifically, there's a long history of police abuse of the LGBT population. From regular raids on gay establishments in the 60s, culminating in the Stonewall riots of 1969. NYPD treated queer community with unwarranted suspicion and targeted queer New Yorkers with violence on the basis of their sexual orientation and identities. Throughout the 60s and 70s, NYPD engaged in a program to surveil the queer community. Surveillance and harassment continues to this day. In 2013, the New York Times wrote a piece about NYPD harassment of LGBT New Yorkers in Queens. In 2017, a transgender woman was arrested for giving false identity to law enforcement when she gave both her current and previous legal names. In 2020, NYPD attacked New York City's Queer Liberation March, beating marchers with batons. And it wasn't until 2021 that New York repealed its walking while trans law, the crime of loitering for the purposes of prostitution, which was used by NYPD to round up transgender women indiscriminately. In short, LGBT New Yorkers have been at increased risk of law enforcement surveillance, stop and frisk, arrest, and incarceration for decades. Unsurprisingly, these risks are compounded for queer, Black, and brown New Yorkers. And just very quickly, I want to say at this time, when the federal government and other states are cracking down so hard, especially on transgender Americans and transgender New Yorkers, it's really important that New York is a safe harbor for these communities. And when we have a database like this that gives the police authority effectively arbitrarily to increase surveillance, increase police interaction, increase likelihood of stop and frisk and arrest of communities, it's extremely likely that the LGBT community will be on the wrong end of it, and we urge you to erase the database.
Thank you.
Good afternoon. My name is Pilar de Jesus. I'm a Senior Advocacy Coordinator with Take Root Justice. I want to give a shout out to my Take Root gang. I'm here today before you not only to urge you to abolish the NYPD gang database, but to demand that we confront the deeper truths about what the system represents. This isn't about public safety. This is about control. This is about surveillance. This is about criminalizing Black and Latino youth before they even have a chance to fully step into their own lives. Over 95% of individuals in the database are Black and Latino. That statistic alone should tell you everything you need to know about its purpose. It does not target crime, it targets people. It does not serve justice, it serves racial profiling. It does not make New York safer. It ensures that generations of young people, particularly those from poor communities, are kept under constant threat of criminalization. Let's be clear, it's not illegal to be in a gang, and yet the NYPD treats inclusion in this list as a scarlet letter. An invisible mark that follows young people through their lives, often without them knowing. A young person can be added to something so arbitrary as to where they live, who their friends are, or even how they dress. There's no transparency, there's no oversight, and there's no way to challenge the inclusion. And once you're in it, you're in. No due process, no appeal, just a lifetime of heightened certain security and criminal suspicion. If this database was truly about crime, why aren't Proud Boys in it? Why don't you see wealthy white criminal organizations subject to the same surveillance or restrictions? Because it's not about justice, it's about oppression. It's a digital form of stop and frisk, a way to keep Black and Latinos communities under constant NYPD watch, feeding into the cycle that limits opportunities, increases interactions with the criminal legal system, and sets young people up for failure before they even had a chance to make a choice. Let's talk about the long-term harm. A young person in a NYCHA can be labeled as a gang member simply because of where they live. That label can impact their ability to get jobs, access to housing, and further education. Let's just try to get to the root of the problem, and let's really abolish this database.
Thank you.
Oh, good afternoon, Chair Salam. I'm Christina Chase. I'm a long-term resident of New York City, a lifelong. And I'm also an advocacy coordinator at Take Root Justice, along with Pilar. I'm here today to center the concerns and demands established by one of our coalition partners, the Gangs Coalition, and to speak on and advocate for NYCHA families disproportionately harmed by these practices and policies, and to demand for the abolition of the Gangs database. I've lived in public housing since I was 6. Now I'm raising my son in the community I grew up in, Ravenswood Houses, and he's 2. I was taught, and I teach my son, to say hello to all of his neighbors. It scares me to think that my son, Mateo, can end up on a list that criminalizes him simply for saying good morning to his elders. I'm sorry. It infuriates me that we have to live a different life because of being public housing residents. A life of hyper-surveillance and hyper-policing. I'm sorry, I get sensitive when I talk about my son. It is part of our everyday lives as NYCHA residents to feel like we don't belong, to feel like a criminal just for being, to feel like a second-class citizen. And the Gangs database is a living document that substantiates this. As we know, being put on the Gangs database leads to harsher sentences and higher bail bonds that extinguish possibilities of a second chance, innocent or not. It is a setup. Our children are placed on this list, hyper-surveilled, and then roped further into a carceral system depending on who they know and how they represent themselves. It is a setup. We usually can't pay for the bonds and affirmatively navigate the legal system. It is a setup. And then we lose our child. We lose our child to a system that never saw them as innocent, that never saw them as child. It is a setup. I can only share with you my own experience in my own gendered light-skinned body, meaning I cannot convey to you the experience of young black and brown boys and men that have their childhood stolen, their innocence erased, and their spirits murdered the way they are telling you here today. But I will still speak with my own experience of having a home raided by police for association with someone they're looking for. My own experience as a young person that has been stopped and frisked more than once. As a NYCHA resident who fears and mistrusts the police because of the violence I've endured and witnessed. And as a mom who weeps for every mother who lost her son, her baby, to this carceral system. This database does not lead to justice. It leads to death, metaphorically and literally. I implore you to listen and respond to the testimonies you hear today from the people of New York. Our children, our brothers, our men, our fathers, our families need you to step up. Council members, abolish the gangs database now. Thank you.
Thank you. I appreciate your testimony.
Thank you.
You can just call the next panel.
I'd like to call the next panel. If you are in the room, Marquise Jenkins, Adam Friedland, Sharon Brown, Emily Miller, Larry Nickens, Louis Sturbier, Sterier. Thank you. You may begin in whichever order you would like. Just remember that when the chime starts, try to conclude your testimony. Thanks.
Hello? Hi. My name's Adam. I prepared a statement. If you'll excuse me, I've never been to a committee session before. I've never been to the city council. And in light of what we've heard today and the gravity of the subject matter, I don't feel like it's, it feels trivial. It was about something totally different. I just want to let you guys know, a lot of people, myself included, people have like kind of lost faith in our institutions, and seeing people standing up for children today, and I'm inspired by the work of the chairman and Mr. and Jumani and Councilperson Cabin and Stevens. I don't want to make my statement. You guys are awesome. I mean, this is awesome. So I support, I didn't even know about this, but I support it. I've just been watching. Hey, give it up for yourselves. You guys are awesome. Give it up for yourselves. This is really cool. This actually matters. Most everything is bullshit. This actually matters. And I won't waste any more of your time. I'm just inspired by all of you great people here today. And if by any chance the person that did the graffiti by my house that said Jews suck, if by any chance he's watching it, you know, just I don't know if he likes the city council, but hopefully he's watching it, and we could, you know, hang out or something. We could talk about it, and it hurt my feelings. But but who am I to call out a fellow citizen, especially in light of everything we've heard today? So keep kicking ass, everyone. Give it up for yourselves. This is. Oh, it's okay. Thank you a lot, everyone. All right.
Thank you.
Hello, my name is Sharon Brown, and before I start, remember the hostages, release the hostages, let Yahweh's people go, defend Israel. Okay, so the public safety, we can always keep Israel's safety in the forefront. I believe that the databases should also include Palestinians. They wear the scarves, and they target Israel. So if they're going to have a gang database, I think that that should be included in the gang database. I think that when people say that the databases are racist, I don't know necessarily that that's true, that they're racist, but they can come across sometime as biased. There needs to be a way to better that. So if they are going to use these kind of databases, they have to have a better criteria for why they stop people. They can't just stop people because of some kind of bias. And someone that is wearing a Palestinian scarf, that would not necessarily be a bias considering the terrorism and things that have occurred. So something like that wouldn't necessarily be racist or biased. But setting up shop in one particular community would not be beneficial because, again, some people have said it marks someone for a long time. They can't get housing, they can't get jobs and things like that. So we know what does not work in our communities. As far as the police and the community, they need to get together and make some criteria for these databases. So they should have some kind of overall meeting where they determine what and how the databases should be used. I don't know that we need to throw it away completely, but we do need to make sure that it's not done in a way that's biased. And again, remember Israel, defend Israel, release the hostages.
Thank you.
Public safety, Yusuf Salam.
Oh, just press the button. Yes.
Good afternoon. Two officers. No, you're public safety. Anyway, good morning, sir. Good afternoon, sir. My name is Emily Yuexing Miller, and I'm very touched and invigorated, on the other hand, by a lot of speakers here to reflect all those various issues in the community. As a community leader that was invited in 1990 to help America, I feel for all of what you said. You know, actually, I graduated from grad school here in Manhattan, and I also lived in Manhattan for 37 years. And unfortunately, when I was fighting for our community, I also got injured when I was in Brooklyn. And I was, like Celine mentioned about people who live in particular zip code get racially profiled or discriminated. So I had been always lived in equivalent of a Madison Avenue kind of a neighborhood in my parents' home, and I was always representing people from senior to adolescent. And in here, I happened to live in a zip code everybody thought was not too bad, so they fear for being attacked or racially profiled and would always ask me, because when I show my driver's license, probably would help them being less discriminated. So that's why they always, while they're working hard, they always have me to represent them. And instead I got badly beaten because of my appearance as an Asian. So I really think all of you brought out very, very important, crucial issues about how this leading city of the world should treat our people that's from a very diversified background and different age groups. And recently, I also encountered situations about people who actually married U.S. citizens for green card, which I always warmly embrace them if they truthfully love this American lady and just like they love our country. But instead, some of them are not cooperative. They do have a temper issue that leads them to violence, and I do hope our city would do something about it. And I did have some reports submitted to district attorney. I believe it's, what is her name? Not on top of my hand, it's in my email. But anyway, thank you very much for listening.
Thank you as well. Thank you. I'd also like to call up Yvonne. Perfect. Just press the button. Thank you.
It's on. Hi, sir. Honorable sir and committee. It's an issue that unfortunately started May 11, 2006. Stalking issue. I'm having the pain since Saturday over my heart. I had a heart attack June 25th, 2024. I say it's caused from the man above me doing something with electricity that makes me very, very sick. I went to the emergency room, and when I went to the emergency room from 11 o'clock until 3 in the morning, the wonderful staff marched back and forth while I moaned in pain, and my pressure went to 216 over 109. But the stalking is pretty bad because I'm on the property of MTA, paying my fare, minding my business, and you're harassing me. I leave this building, now you march at me, who I don't know, harass me. And it's now 20 years. Now, it's drug-related. I don't do drugs. And the wonderful man who wants to be dictator for a day has an issue with drug dealers. But then I don't understand why all those complaints to Bloomberg, de Blasio, I can't even get to it now. I'm lost. I'm lost the amount of police commissioners. I'm lost at IAB, CCRB that doesn't handle stalking. Mr. Darsh, nice man, and the rest of them, they don't handle stalking. I cannot come up to you, grab at you, reach at you, touch you, assault you, and police stand and watch. Big problem, Honorable Sir. And I tried to reach you before you became who you became, but I couldn't reach you. I called your office last year and spoke to Shawnee, and I had a letter for you to see that, because since 2009, letters have gone to presidents. Every bus and train camera has seen those letters. They have been given to White House staff in the days of Obama, Forster, Marshall, and one to Ronald L. Davis of Cops Division. That's the White House. Many people, different, the governor, Governor Patterson. 1 year left in Obama, 1 year left. I see Governor Patterson, and I say, my name is Miss Jennings. Until your last day in office, I reached out to you. You remember Miss Katie said, yeah. You remember Larry Lawson? Yeah, it's a stalking issue. And he went on to say, because he's blind, he went on to say that he worked in the Brooklyn DA. But this is now how many years ago?
So because
Obama, 10 years ago? This is now 20 years. But he got all those calls and emails. I wonder where they all go.
Because your time is up, I want to offer.
Yes.
I have my chief of staff here who will help you.
Yes.
And we'll connect with you to figure out ways forward.
I just want to speak to you if you had a moment. Greatly appreciated if you could speak. Because I did speak to the wonderful lady a moment ago. But if I could speak to you, greatly appreciated if you can. Okay? Thank you. Very urgent. Thank you.
Thank you. We'll now turn this over to our virtual panelists. For virtual panelists, once your name is called, a member of our staff will unmute you, and the Sergeant-at-Arms will set the timer and give you the go-ahead to begin. Please wait for the Sergeant-at-Arms that you may to announce that you may begin before delivering your testimony. I'll now call our first virtual panelist, Lisa Freeman.
You may begin.
Good afternoon. Thank you so much, Chair Salam, for your patience with this hearing. I am only going to be specifically testifying about INT. Oh, I don't have my camera on, I see. Apologies. Here we go. There we go. I'm only going to be testifying about INT 125 today. Other folks from the Legal Aid Society have spoken about the gang database. I am the head of our Juvenile Rights Practice Special Litigation and Law Reform Unit. The issue of the taking of minors' DNA without parental consent is an incredibly important issue. As you may know, the Legal Aid Society has sued to stop the NYPD's unlawful DNA index, which includes DNA taken surreptitiously from adults as well as children. The whole concept that anybody can abandon their DNA is, I think, completely a false concept and one that's in fact unlawful. But we vigorously support Councilmember Ayala's bill, but believe there are several necessary amendments. First, I just want to mention that children who are charged as juvenile delinquents can never be included in the lawful state DNA index because they statutorily cannot be convicted of a crime. So anyone who's not convicted cannot be in the state DNA index. So the whole concept that NYPD has its own index that includes people who are not convicted is unlawful and completely problematic. But they certainly should not be including children. One of the, under New York state law, the law enforcement has to obtain a warrant order or a court order before getting a DNA sample from anybody unless the person consents. But the idea that a child can consent to the taking of their DNA, that they can understand what that means and the long-term consequences of that action is a completely flawed notion.
Thank you. Time's expired.
Can I just finish one sentence, please? Our problem, I will be submitting written testimony, but our problem with regard to 125 is that we don't believe that parents are in a position to consent for their children because all too often they're not able to look out for their child's best interest. And instead, we think an attorney should be provided to the child if, in fact, they're going to not get a court order for that child's DNA. Thank you very much.
Thank you. I'd now like to call Tanisha Grant.
You may begin.
Hello. Thank you for this. My name is Tanisha Grant, and I am the Executive Director of Parent Support and Parents New York. Thank you, Chair Salam and Public Safety Committee for this important hearing. We fully support Intro 798 and Intro 125. The gang database has been a way for NYPD to racially profile and criminalize our children and young people. If it wasn't, it wouldn't be 95% Black and brown people on it. As Council Member Stevens mentioned, we have many gangs of different ethnic groups, yet all resources are focused on our communities, which leads a false narrative about our youth. We are very pleased that the New York City Council is trying to address these racially systemic issues that have been a curse on our communities for decades. The NYPD aren't really concerned about public safety. They are concerned about locking up our children and labeling them as gangbangers. I hear this talk about at-risk youth, but the Community Affairs Department within the NYPD that is supposed to engage with our youth and communities have a very low budget. It is time that the gang database and taking DNA from minors be stopped immediately. We also need to talk about how guns get into our communities in the first place. Oftentimes, guns and gangs are in the same sentence. The unlawful over-policing and criminalization of Black youth has taken a severe toll on our youth's mental health. We must stop the overfunding of the police and start really putting resources and real opportunities into our community. I will send the rest of my testimony, to you. Thank you so much.
Thank you. Now I call Christopher Leon Johnson.
You may begin.
Hello?
You may begin.
Yeah, hello? Hello? Can you hear me?
We can hear you.
Yeah, hello. Hey, my name is Christopher. Hi, my name is Christopher Leon Johnson. I'm here to be opposition to the gang database abolition bill. And I'm going to explain why. Is because these bills benefit nothing but the corrupt nonprofits. It benefits these nonprofits that just want the money from what they spend in the gang database. I spoke about it before. I know this bill is about, this was like the last time when I was in the rain, testifying in the rain in Brooklyn. Like I said, this is nothing but a redo of the last bill that he did. Okay, you can't, the gang database bill is controversial, so let's now call it criminal organizations. Now, what's next? A criminal, or y'all just redoing bills to say like, well, we get this one bill done, we'll get rid of gang database. Look, we need this bill. Like I said, Vicky Palladino hit it on the head, said that look, there's a criminal migrant problem in the city of New York, and we need this. We need this for the criminal the criminal migrants in the city. But I want to give a shout out to Natasha Williams about what she said about the Explorer situation. That look, yeah, there's a gang problem in the city. There's a lot of bad people in the city that needs their help and the resources. But she was correct about the Explorer program when it comes to the youth outreach, where they don't select the bad kids. They don't select the criminal crop between the good kids. Like, I understand we want to cure violence in the city of New York. We want to cure violence everywhere. But how are we going to cure violence when you're only picking the good people? That doesn't do anything. It's like having a thorn on your nail, like a thorn on your tip of your finger, and you need to get it pulled out. And the only way you get pulled out is by using your finger, again, like a prick or like a tweezer, and taking the thorn out the finger. At the same time, you're just saying, let's put water on it. You know what I mean? It's stupid. It's counterproductive. But she's right about that. Natasha Williams is correct about the whole Explorer situation. That needs to be fixed. You need to start recruiting all the bad kids and put them in the programs.
Your time's expired.
So thank you so much. Enjoy your day. I got to go.
Thank you. We've now heard from everyone who has signed up to testify. If we inadvertently missed anyone who would like to testify in person, please visit the Sergeant at Arms table and complete a witness slip now. If we inadvertently missed anyone who would like to testify virtually, please use the raise hand function in Zoom, and a member of our staff will call you in the order of the hands raised. Seeing no one left, I would like to note again that written testimony which will be reviewed in full by committee staff may be submitted to the record up to 72 hours after the close of this hearing by email, sending it to testimony@council.nyc.gov. This hearing is now concluded. Thank you.